So let us begin our discussion further. I have told you so far the method of learning, and I have told you also how this CPC moves little bit, but we are required to know further. Now CPC in very simple terms is civil procedure, and as far as any law is concerned, generally we have statutes of law. So this CPC also has a statute called Civil Procedure Code 1908. Now in this Civil Procedure Code, generally we have this issue that there are sections and orders which is not there in other acts as such, and that is why students will generally have some kind of confusion, कैसे पढ़ें, क्या करें. हालांकि वो पढ़ चुके होते हैं, they have read the CPC at various levels, but even then they have certain doubts in their mind. Why this section and why this order? So I have told you, and I am going to say this again, that see in this CPC, we have one part called sections scattered in part 1 to 11, section 1 to 158, and there is other part of orders that is 1 to 51. Now as far as sections are concerned, they basically deal with the question of jurisdiction and powers. Like section 9 says that civil suit will be tried by civil court. Section 16 to 20 talks about territorial jurisdiction. 15 says that you have to reach to the lowest court. Now this is all general points, but it is written in section part. So section 9 gives jurisdiction to try a civil suit. Section 16 gives jurisdiction to civil court, that if the property is situated at place A, then place A court will have jurisdiction. But what this order does and what other orders do, what these 51 orders do? So basically they prescribe the procedure, they prescribe the rules, they prescribe the procedure, they prescribe the methods. Now the moment you said the civil court will be approached by civil suit, now the question will arise, how will you draft this civil suit? So section 26 said that civil suit will be instituted by filing a plaint. But how will you file a plaint? What is the methodology? What are the rules, regulations, procedures to be taken care of in filing a plaint? And that is given in order part. Order 7 rule 1 says what will be contents of plaint. Order 6 says how this plaint will be drafted. The rules of pleading will apply. Plaint is pleading for plaintiff. When I go to the court as plaintiff, then I will file pleading as plaint. And if you come as defendant, then you will file your pleading as a written statement. So in both cases, the question will arise that what will be contents of these statements, either of plaint or of written statement. What rules, regulations, procedures have to be followed. So that is given in orders. तो पहले आप इस बात पर क्लियर हो जाएं कि सेक्शंस जो है वो सब्सटेंटिव पार्ट है और ऑर्डर्स जो है प्रोसीजरल पार्ट है सीपीसी के. अब जैसे ही आपने कह दिया सब्सटेंटिव पार्ट, आप सब्सटेंटिव लॉ में मत ले जाइएगा उसको. Substantive part means where we have conferred powers and jurisdiction on court. Whereas procedural part means where we have prescribed the procedures to reach to the court, the methodology to reach to the court. So sections and procedures हमने दोनों लिखे. One is written in, I said CPC is divided into two parts, sections and orders. There should be nobody in my class who should have any kind of confusion. Order 1 to order 51. Order 1 to order 51. This is Roman, L is 51. So 50 plus 1, right? You write. So 50 plus 1, 51. 50 is for L and 1 is for this. And this is 1. 1, 2, 3, 4, you might be aware. Alright? And sections 1 to section 158. This is in part 1 to 11. This is how CPC is organized. I gave you a very interesting task to see which sections are related to which orders. If you do it, you will be involved in it. And the best method of learning is that you involve yourself more and more. So I gave you this task and I hope almost all of you, rather all of you have done it. Is this so? Everybody has done this task. You write on one hand sections, on another hand orders. And this is how you can memorize things better. Though I'll share more techniques to memorize today. But I hope you have done this till this point. And if you have done it, you will have little bit comfort in understanding and remembering these sections and orders. Is this all right? Is this clear to you? आपने किया sections and orders. आज हम थोड़ा सर्वे करेंगे पूरे पार्ट का, पार्ट 11 ऑफ दिस CPC. पहले पार्ट वाला करते हैं हम, फिर आप ऑर्डर्स वाला करोगे. अब देखो पार्ट 1 से स्टार्ट करते हैं. आज CPC का आपको सर्वे कराते हैं. दिस इज प्रिलिमिनरी. अब कैसे ध्यान, मेरा अभी स्ट्रेस इसी बात पर है कुछ इनिशियल क्लासेस में, हाउ टू memorize things. Now we discussed on the first day that there will be many questions related to Bare Act. So if you start reading Bare provisions, before that you should have little bit clarity how to do it, because otherwise you will be now wasting your enormous time. The things which should be done with little effort will be done with enormous effort. So choice is ours, whether we want to do it easily or we want to do it in cumbersome method. So if you listen to me, you will be doing it easily. I am very sure about this. अब देखो हम प्रिलिमिनरी पार्ट से स्टार्ट कर रहे हैं. एक ना एक्स्ट्रा पार्ट है सीपीसी में, प्रिलिमिनरी. इसका कोई आपने नाम नहीं दिया है, इसमें आपने कोई नाम नहीं दिया, बिकॉज द रीजन विच you can appreciate and understand is that, see, in this preliminary part, you have written about preliminary things. You are not discussing the matter of civil suit. That begins with section 9. The question begins, where will you file a civil suit? So you said civil court. Why civil code? Because it is question of civil rights and civil remedies. And what is civil? That is clearly known to everyone. Generally speaking, what is not criminal is civil. So there are two kinds of basically wrongs and remedies in our legal system. One is civil and another is criminal. We'll be discussing that more in section 9, but here just to begin with. Now civil basically contract, marriage lodge, succession lodge, rights related to properties, etc., contract related rights, they are basically civil in nature, transfer of property. So ये सब civil है. So they are taken care of by CPC because they are all civil, be it transfer of property, be it marital rights, be it contract rights. So they are all civil in nature. They are private in nature. But there is no such distinction that one wrong which is civil will never be criminal. So if you think like that, there is no mutually exclusive territory of all wrongs. A wrong may be civil as well as criminal. Many cases it may happen. Many cases it may happen. It may be there so. And you may ask how it is so. So how do you perceive it? Now see, malicious prosecution or rather wrongful restraint or confinement. Wrongful confinement results into loss of liberty. There is remedy in tort law, which is civil remedy. But this wrongful restraint or confinement, rather wrongful confinement, which is called in tort law false imprisonment, is a criminal wrong also. It's a criminal wrong also, because wrongs against liberty are described there in chapter 16 of IPC. So wrongs related to liberty is there as well as here. In civil law domain it is there, in criminal law domain it is there. You may raise a question why it is so, how it is so. So let us tell you very briefly. Very briefly, it's interesting. We'll discuss it time and again, but here once let me share with you. Now see, when this society came into existence, we had a kind of pact called pactum unionis. So जब ये समाज बना, when we created this society, then there was pactum unionis. हाँ, एक कमेंट आया सर, पार्ट 1 इज सूट्स इन जनरल. ये मुझे नहीं पता था. थैंक यू वेरी मच. थैंक यू वेरी मच. थैंक यू श्रेष्ठी. थैंक यू. गॉड ब्लेस. हाँ, सो पैक्टम यूनियनिस. अब क्या हुआ, मेरी बात ध्यान से सुनेंगे, मैं आपसे जब पूछूंगा तब आप लिखिएगा. पैक्टम यूनियनिस, बात को बहुत ध्यान सुना और बहुत आराम से सुना. इट्स ए स्टोरी. I said in the first lecture itself that I will not be teaching you, I will be now sharing with you some stories here. So just listen to me. It's very interesting story. Pactum unionis. It means very many people came together. Now people used to live as nomads earlier and they used to live in isolation. They were almost like animals. But later on they started to begin and gather and to live or settle somewhere now. Settlement was near that area where there was water and plenty of food, etc., etc. So that is all the story you read here and there how human settlement took place. Pactum unionis means pact, pactum pact, that is agreement. मैं आपको story सुना रहा हूँ, ध्यान सुनिएगा. And unionis refers to basically a kind of union, a kind of group or association. So people had agreement of association and they gathered together at one place. So they had certain rule for their own conduct, that I will not harm you, you will not harm me, something like that. It's very simple, general. So we had a pact called pactum unionis, where people gathered together and they started living in groups. Then when this group became larger, then there was problem that how to control this behavior of the entire group. If anybody does wrong, what kind of treatment should be given to him. Is this clear? So we came with a new formulation of another pact, and that is called pactum subjectionis. That is pact of subjection. That we created an authority who will sit above us and we will be subjected to them. We will follow them. So that is how concept of governance or government or sovereign came into existence. That is the initial phase how this structure came into existence. So pactum subjectionis is basically pact of subjection, whereby I accept your authority that you will command my conduct, and if I do any wrong, you will be able to punish me. But at the same time, you have been given task to protect my interests. And that is what is a pact. I will obey your rule. Suppose you are sovereign and I am your subject. So I said I will obey your rule, but you will have to protect me. So you gave me promise that yes, I will protect you. Now what happens whenever any wrong is done to me? The state has an interest in that. How state has interest? Because of this pact. There is an implied agreement that if I am national of this country, this nation has a duty towards me as well. And that is how concept of fundamental right and DPSP has come into existence. That see, country also has certain duties towards you, and you have certain rights against the government of the country. So we have right-duty relationship. State gave us that kind of promise that I will protect you wherever you are. I will protect your interest, your property, your body, your reputation, your marital relation. State has given so many promises to us, and we have given them one promise that I will abide by your rule. Is this clear? This is what is pactum subjectionis. Now suppose somebody comes and he wrongfully confines me. I talked of wrongful confinement. So state has given me promise, or state has given me guarantee that I am free individual in this state. So if somebody curtails my liberty, is he not questioning the authority of state? The state which has given me guarantee that he or the state will be protecting my liberty. So is it not violation of the authority of a state? The answer is yes. But at the same time, as he is violating my right, my private right of liberty as well, so can I file a suit against him? The answer is yes. So in this situation, I can file a civil suit because I have suffered some damage, I have suffered some wrong, and at the same time as a state's protection, which was promised to me, is also violated, is also questioned. The state's authority is questioned. That see, you have given now guarantee to all of your individuals that you will be protecting them, but I am interfering with your this promise of protection. So whether that person is violating the state's authority or not, or questioning the state's authority or not, the answer is yes. So this wrongful confinement will fall in the category of civil wrong as well as in the category of criminal wrong. Is this clear? And that is how you will read in IPC that starting from chapter 6 of IPC till chapter 22 of IPC, all the chapters are basically chapters of protection of different interest which we have, which state has promised to protect. Like interest in my body is protected in chapter 16 of IPC. Interest in property is protected in chapter 17 of IPC. Interest relating to my marriage is protected in chapter 20 of IPC. So this is how my different interests are protected by state by enacting certain criminal law. Now you may raise a question, Why state enacted criminal law for protecting the same interest for which we have civil remedy? The answer is very simple. And the answer is that, see, if somebody comes and questions my authority as private individual, somebody has contract with me and he violates contract, nothing doing, no problem, state has no concern. So I will file a suit against him, that's done. I will claim damages, no issue, for violation of contractual promise. But if he violates any of the promise of state, the promise of liberty, the promise of protecting my body, the promise of protecting my property, if he violates any of my right, there in that law, then obviously he is questioning the authority of a state. And if a state is not harsh in its punishment, a state is not harsh in its action, perhaps it cannot maintain that discipline, decorum, order in the society. So just to create that kind of impression in the mind of everyone, that if you violate state's guarantee, state's promise, then you will be taken to the task. You will be given punishment. So it is not question of individual right in that case. If a person is murdered, it is not question of his being murdered only, it is question of state's authority of protection of that person's body is also questioned. So state has to step in. And the state will punish, obviously. State will punish because state wants better protection of individual living in that state. So that is why in various situations state will punish the wrongdoer. Loss of life, where life is guaranteed, natural death is allowed, that's not within your control. But unnatural causing of death by anyone of anyone is obviously a grave concern for the state. So state makes it criminal. It is the same wrong which is criminal and civil. Now you may again say that I understand everything. But how it can happen? So I will give you a very simple example. See, I am Alok Kumar Ranjan. I am son of somebody and I am father of somebody. I am son of Sri R.P. Singh and father of Master Aryan Ranjan. So my position changes as the context changes. So it can happen. You may be student in this class, but you may be master somewhere, teacher somewhere in your class. You may teach some students. So there your position will change. So it is question of context. It's not mathematical. Law is not mathematics. Law mathematics नहीं होता. मैंने कई बार कहा है, आपसे भी कह रहा हूं. Law is not mathematics. And nobody can treat law as mathematics. So be careful, my dear friend. You will have to keep these things in mind that 2 plus 2 is not always 4. 1 2 का 4 भी होता है. 1 2 का always 3 होगा, ऐसा नहीं है. So you have to be careful about that. Is this all right? तो ध्यान रखना होगा कि परिस्थितियों के अनुसार चीजें बदल सकती है. So I said same wrong may be civil, same wrong may be criminal as well. It depends on context. Obviously theoretical differences are there. Criminal wrongs are treated by state will initiate action. Civil wrong, private party will initiate the suit. So there are differences. Procedure is also different. The remedy is also different. In criminal law, remedy lies in the form of punishment. In civil law, remedy lies in the form of pecuniary compensation. So all these differences are there, which we will be studying in tort also and in crime as well. Not in CPC exactly, but I have told you all this just for your understanding at the outset. So what we are going to discuss? We are going to discuss that whenever a civil wrong is committed, what will be the remedy, recourse, the procedure? How will we seek remedy? So basically CPC is nothing but a journey from right to remedy, wrong to remedy. What is the wrong? If it is civil wrong, come to civil court. And then the relief. How will you reach from this wrong to relief? This is the journey of CPC, in very simple terms. In very simple terms. So you have to be careful about this fact. We are still now we still have some time to enter into that journey in particular. Because I am not in hurry, you should not be in hurry. You will have to give yourself little bit time to think over. You will have to now synchronize your understanding with this civil remedy, civil relief. And I will suggest you, if you want to understand this subject better, have little bit idea of other acts of civil law also. Because we'll be using this time and again here and there. Little bit idea. I said you should have awareness. I am not saying that you should have read all those subjects. No. But you might have read, and if you have not read, I'll be explaining them time and again. Don't worry for that at all. I'll be explaining that. Whenever I use the word of any other civil law, I'll be explaining it to you. But for your kind information, if you have seen Contract Act, TPA, specific relief, Hindu law, all this is going to work better for you. If you have not read, don't worry, I'll explain everything to you in this class, whenever there is necessity as such. If there is no necessity, we will not go in those territories. Is this clear? Yes. I hope you all are clear. So you understand pactum subjectionis and pactum unionis. Is this clear? Pactum subjectionis and pactum unionis. Somebody have always some problem in class, so they have to take care of this fact that at our end we can help you, but at your end it is very difficult for us to help you what to do, and will not be sure and certain what kind of problem you are facing. And it is era of technical things, so I may not be sure that what kind of problem you are facing. So please be in touch, and please be in touch on time. Don't write message at now at 5 p.m. exactly to Mr. Ranjan that Mr. Ranjan cannot help you in that regard at 5 p.m. And Mr. Ranjan is not supposed to see all these things, because then Mr. Ranjan will not be able to see CPC. So you take help of those people and they will help you. There is no reason of not helping, because the institute belongs to you and you belong to us. So if there is any kind of technical problem which you are facing, then you please contact them, they will help you. I will tell them also on your behalf that please help them. If there is an issue, some people are not able to attend class due to their what they have written, we are not able to see our class in laptop, etc. So there I am really helpless, and they will be helping you, because it is available on this app and laptop also. You can see, I have also watched my lecture on laptop, and always the lectures delivered earlier are available there on your app, so you can revise them as well. But I will say that sitting in class and concentrating in class is always better, and writing everything. Though I have not started any dictation. A student at the outset has many confusion. Now, so you keep aside your confusion. Whatever confusion you have, you please keep it aside. That's the best suggestion which I can give you. I am not giving any dictation right now. Dictation will come later on. अभी तो मैं आपको सीपीसी के बारे में जनरल बातें बता रहा हूँ, थोड़ा समय लगेगा इसमें. अब जैसे सेक्शन 9 विल टीच, सो विल गिव डिक्टेशन व्हाट इज सिविल सूट, व्हाट इज एक्सप्रेसली बार्ड, इम्प्लाइडली बार्ड, right to office, right to property. There are many things to be explained. So that is where this dictation comes. Dictation doesn't come in this case that part 1 has these sections and part 2 has these sections. No, this is not in dictation part. All right. So don't worry for that. We'll learn everything. We'll learn every skill in this class. We'll learn the art of answer writing. We'll learn the judgment writing. We'll learn how to memorize, but everything will come on time. It is not yet that stage where we can discuss all those things. We'll be discussing them. Don't worry for that. मैं पहले पढ़ाऊंगा आपको तब तो आंसर बताऊंगा कैसे लिखना है. In the beginning, we'll be talking about in general things, and that is what we are doing. That is why we have so many classes in CPC, otherwise it is all unnecessary. We can finish CPC hardly in 20-25 lectures, maybe 30 lectures. Why we have given so many lectures? To make you, now see what we are going to do in this class, those people who have confusion, we will be dealing with sections and orders. We will be talking about memorization of them. We'll be giving dictation on the topics. We'll be doing all that. I'll be telling you time and again how to write answer, because this is one subject where there are many men's questions which is supposed to be written. We'll try to answer all questions asked and to be asked in examination. We'll try to answer, but first it is your duty. First it is your duty to answer all these questions, not the duty of teacher, because teacher has to teach and then you have to solve, and if you do not understand, you will have to ask the teacher consent to help you to solve the question. But you are the master of the affair. Like Dominus Litis, master of the suit, you are master of the class. So you have to take this responsibility, and I will help you in performing that responsibility, don't worry. If you do not understand anything, you please ask me. Towards the end of class, we have that question answer session towards the end. I will be helping you regarding that. So that is not at all an issue. Is this clear? So no worry, cool down, sit silently, we'll do everything, whatever is required for the examination. If you apply your mind too much, then there'll be problem. Because if this problem creeps in now everybody's mind or somebody's mind, then you will not be able to concentrate. अब जैसे मैं अभी आपको आज ओवरव्यू ऑफ सीपीसी बता रहा हूँ, आप कहने लगे डिक्टेशन, तो ओवरव्यू में हम डिक्टेशन क्या देंगे आपको भाई? मैं तो ओवरव्यू दे रहा हूँ. सो इन ओवरव्यू नो डिक्टेशन इज देयर. Dictation will come and we'll pick up the topic as such. So I was saying that we'll survey this. So first part is preliminary in that sense. Preliminary is section 1 to 8. अब देखो कैसे ध्यान करते हैं, मैं थोड़ा मोड़ा आपको बताता रहूंगा, so you be careful. Then there is part 1, suits in general. So this is not named part. The part begins from here, section 9 to 35b. If you remember 8, so you know that this will begin from 9. So you have to just think of. And 3, 5, how much? It is also 8. 3 plus 5, 8. I have told you the other day also. Then part 2, suits in general. Then part 2 talks of execution. So section 35 के बाद क्या आएगा? This is 36. And it will go up to what? 74. 74. मैंने आपसे उस दिन में बताया था 6 plus 3 is 9 and 7 plus 4 is 11. So 9 2 11. मुहावरे पढ़ते हैं ना for Rajasthan type examination. No? Any other examination. Part 3, just quickly इसको कर ले हम लोग. Part 3 is commission. 75 to 78. 75 to, so 3, C3. C is third alphabet. C3, third alphabet, 3. Part 3. Commissions. Commission, is this clear? Then part 4. Incidental. Incidental, no, incidental तो यही, ओहो, sorry, sorry. Incidental proceedings is this, जिसको मैंने commission लिखा है. This is basically named as incidental proceeding. Part 4 is basically now this special, now suits in particular. Suits in particular. All right. So, suits, particular suits you can write, no? That is better language. You can develop many methods, great. Particular suits. These are different kind of suits. 78 के बाद 79 to how much? 88. I said that day 7 plus 9 and 8 plus 8. Both is 16. This is how now you can develop your own method to memorize. Don't copy my method always, you can follow your own method. But the point is that you should be able to memorize. You should be able to memorize. Is this clear? आपने सही लिखा है शुभम चौहान. हाँ, interchange and add 6, 7, 3, 4. All right. All right, you can develop your own method. Now this is one very important task I tell you, and even within this you are required to memorize many sections. So this memory techniques are very very important. मैं पहले इसको पूरा पार्ट बता दूं, फिर मैं अंदर भी sections पे थोड़ा बात करूंगा. मैं आपको थोड़ा बताऊंगा how to memorize. हम section 2 पे भी जाएंगे थोड़ा बहुत. पहले कुछ classes में मैं चाहता हूं you must learn how to memorize things, so that you should have comfort. Yeah. Otherwise you will be reading entire CPC and you will not be remembering anything. So I don't want happen to you. I don't want that happen to you. 89 to 93, not 94. 94, 95 to no, different proceeding, supplemental proceeding. So 89 to 93. अब 89 to 93 में क्या है ये भी हम लोग पढ़ेंगे अभी. We'll see that arbitration is there, opinion of court is there, no? Public nuisance is there, charity is there, compensation is there. We'll see how we can remember that. Special proceeding, this is part 5, no? कौन सा पार्ट है जरा देखना. मैं गलत लिख रहा हूं, मैं गलत लिख रहा हूं, देखो. Is this clear? Did you see in your Bear Act? Part 6, 7, 8, 9, 10 and 11. '94, '95, 96 to 112, 113 to 114, कुछ ऐसा ही है ना? हाँ, पार्ट 5 में मैं भी चेक कर लेता हूं. पार्ट 1 9 to 35 be clear. Part 2 36 to 74. Part 3 75 to suits in particular 79 to 88. Part 5 is 89 to 93. 6 is 94 to 95. 7 is 96 to 112. 8 is this, 8, ये थोड़ा सा गड़बड़ हो रहा नहीं, ये साथ लिखना पड़ेगा. Then 9, 115 to 118. Clear? Then 10, 100, नहीं ये कहाँ लिख दिया मैंने? देखो मैं बहुत सारी गलतियां करूंगा, आपको पकड़ना है। मैं आपको ये टास्क दे रहा हूं, मेरी गलतियों को पकड़ के तुरंत बताना है कि वेयर आई हैव रिटन रॉन्ग। ये सही लिखा है, ये सही लिखा है, अब ये भी सही हो गया। देन दिस 116 to 120 and then part 10 121 to 131. देखते हैं कैसे याद करेंगे इसको हम लोग। And then miscellaneous 132 to 158. All right. भाई लिख लिया सबने? हाँ ठीक किया आपने, करेक्ट कर दिया। 113 to 115. ऑल राइट, बहुत अच्छा, आप लोग सभी लोग इन्वॉल्व हैं। तान्या एंड जिया एंड भूमिका एंड सिमरन एंड दीपिका एंड ज्योत्सना, प्रशांत, वेरी गुड। अनस, ऑल राइट, वेरी गुड। आप सब इसका मतलब देख रहे हैं। इट इज नॉट सो दैट यू आर नॉट लुकिंग इनटू योर बेयर एक्ट, यू मस्ट लुक इनटू योर बेयर एक्ट। ओके ओके, किसी किसी के साथ अभी भी प्रॉब्लम है। भाई सबकी क्लास चल रही है, किसी एक दो लोगों की नहीं चल रही है, तो इसका मतलब उनके एंड पे प्रॉब्लम हो सकता है। तो प्लीज देखिए, कूल काम हो करके, परेशान मत होइए। एवरी प्रॉब्लम हैज ए सॉल्यूशन। नाउ इट इज ओनली क्वेश्चन दैट कैन वी फाइंड दैट सॉल्यूशन और नॉट, कैन वी फाइंड द सॉल्यूशन और नॉट। इज दिस क्लियर? तो हम लोग देखेंगे, डोंट वरी। ऑल राइट, अब इनके नाम क्या है ये भी जरा लिख लें, तो हम ध्यान करेंगे जरा। ये सप्लीमेंटल प्रोसीडिंग्स है ना, देन अपील, देन रेफरेंस रिव्यू रिवीजन, इज दिस सो? Special provisions related to High Court. Special provisions related to High Court, and then rules, and then miscellaneous. Now in every part you will find something important. We'll try to find out important sections and important rules also, so that we can have little bit clarity in our mind. So this much you remember now. अब देखो मैं आपसे ध्यान कर रहा हूं, आपको पहले ध्यान कर लो, फिर से हम लिखेंगे। प्रिलिमिनरी सेक्शन 1 to 8, all have clarity. प्रिलिमिनरी सेक्शन 1 to 8, 1 से 8 तक का प्रिलिमिनरी, सेक्शन 1 to 8. हाउ मेनी सेक्शंस इन CPC? 158. 158. 8. All right. Then suits in general. जैसे ही हम प्रिलिमिनरी से निकलते हैं, पार्ट 1 शुरू हो जाता है, सूट्स इन जनरल। सूट्स इन जनरल इज सेक्शन 9 to 35B. Then when suit has been decided, अब देखो कैसे मेथड, अब तुम्हें ये नहीं देखना है कि केवल रट्टू बनना है। आई एम नॉट सेइंग दैट यू शुड मग अप एवरीथिंग, यू जस्ट ट्राई टू अंडरस्टैंड, you just try to understand. Once suit has been decided, will we not go for execution? The answer is yes. So suits in general, section 9 to 35B. Then 36 to 74, that is execution. 36 to 74 is execution. अब देखो execution में now 36 to 74 exactly. How many sections are there? So almost 39 sections. No? Almost 13, barring some amendment here and there. So 1 to 8, 9 to 35b, 36 to 74. And then after that you have written that incidental proceeding. That is commissions. That is part 3. Incidental proceeding is commission, IC, integrated circuit or whatever you call it, IC, is very important. Now, IC, incidental, commission, and it is in third part, C is third part. Commissions, that is how I remember commissions generally, 75 to 78. यदि ऐसे देखेंगे 78 minus 75, 3 sections are there. So part 3 is there, otherwise 4 sections are all there, 75 included, 1, 75, 76 another, 77 third, 78 fourth. कभी calculation में गलती नहीं करेंगे, these are 4 sections basically, but 78 minus 75 is 3, so part 3. Then you said number 4, suits in particular cases. See, once suits has been decided in general, then there is question of particular suits. अभी order में भी आपको बताते हैं कि starting from order 27 to 37, these are all particular suits. And what kind of particular suits are there? That is very, very important. We'll see that, how to memorize them. Now, so 79 to 88. And then supplemental. क्या है? Supplemental. कैसा supplemental? या special? Special supplemental. पहले तो पर्टिकुलर सूट, देन स्पेशल, देन सप्लीमेंटल. अब देखो कभी ध्यान न रहे आपको तो फर्स्ट विल कम स्पेशल और फर्स्ट विल कम सप्लीमेंटल इन डिक्शनरी. यू टेल मी. You have written special and then you have written special proceeding and then you have written supplemental proceedings. So first special will come or supplemental will come. That is how you are required to keep in mind a little bit. First special will come or supplemental will come? Tell me. Special will come first. Special will come first. So 89 to 93. 89 to 93. अब 89 to 93 भी आपको याद हो जाएगा, थोड़ा सा धैर्य रखना, अभी परेशान होने की जरूरत नहीं है. In 93 we talk of compensation. 3C, C is third alphabet. In 93 basically focus is compensation. 89 is that ACJM, arbitration, conciliation, mediation. 89 is very important. '89 to 93. So we can memorize even that. 90 may you will find opinion. 90, 0 opinion, O for opinion, O for opinion. That is how you can guide your mind. Then nuisance, then charity, then compensation. So how can I remember? If I have to remember that, मैं उस पे आता हूँ थोड़ा रुक करके. Nuisance, charity and commission, NCC. So you will divide many such words. I think this is correct thing. Let me check also. I should not be committing wrong. 91 is nuisance, 92 is charity and 93 is compensation. Again you tell me charities and compensation. Which will come first in dictionary? So this will come first. So this is first. Is this clear? Basically 93 is not there, this is 95. 93 तो advocates की बात करता है, 93 is not important. 93 is not important at all. No, 93 is not important, so we'll not try to remember that. This is written in 95, compensation. और ये बहुत important. देखो जो sections हमारे लिए important है हम उसी को याद करेंगे, सबको याद नहीं करेंगे. हम 93 को याद नहीं करेंगे. मैं अभी आपको छोटा सा लिस्ट बनवाऊंगा, What are important sections? So 91, 92 and 95 are very important section, not 93. मैंने लिख दिया, आप सतर्क हो, मुझे पता है, you will point out, I have pointed out. So I'll try to tell you what are the important sections and what are the important rules also. जहां तक संभव होगा आज की क्लास में बताएंगे, आगे और बताएंगे, but आज भी बताएंगे. So are you clear? Preliminary section 1 to 8, suits in general 9 to 35B, then execution is this 36 to 74, incidental proceeding is that 75 to 78, suits in particular cases is 79 to 88, and then this supplemental special proceeding is there in 89 to 93. अब मैंने कहा special पहले आएगा, supplemental पहले आएगा, मुझे बार बार confusion होता है. You should not be in confusion. There are three kind of proceeding written here: incidental, special, and then supplemental. तीनों में हम proceedings use कर रहे हैं. We are using the word proceedings. Is this clear? So incidental will come first, special will come second, supplemental will come third. Is this clear? So 75 to 78, 79 to 88 and 89 to 93. अब आप ध्यान करो इसको जरा ध्यान से. कमीशंस हो गया 75 to 78, then suits in particular cases, that is 79 to 88, and then this is special provision 89 to 93, and then supplemental provision, now supplemental proceedings 94 to 95. If you remember this much, then proceedings are over. अब आप यहीं पे रुक जाओ, जरा ध्यान से बात को सुनना. कुछ लोग लिख रहे हैं जरूरत से ज्यादा. हाँ भाई, वही मैं भी कह रहा हूं. अल्फाबेटिकल ऑर्डर इसको बोलना सही नहीं होगा, क्योंकि अल्फाबेट तो एस है ना, इसीलिए इसको बोलते हैं डिक्शनरी ऑर्डर. हाँ, आप महान है, मेमोराइज हो गया तो आप परेशान ना होइए, हम लोगों को थोड़ा सा कर लेने दीजिए सर. इज दिस क्लियर? अल्फाबेटिकल नहीं बोलते कनिका इसको, हम इसको डिक्शनरी ऑर्डर बोलेंगे. अल्फाबेटिकल ABCD होता है, ये डिक्शनरी ऑर्डर है. इज दिस क्लियर? पहले मुझे ध्यान देने तो, आप जो लोगों को ज्यादा समझ में आती है, दे शुड नॉट बी इन हरी. हम थोड़ा धीरे धीरे चलना चाहेंगे, एंड आई विल गो अलोंग विद एवरीवन. नाउ many people have many problems, sometimes will be very fast, sometimes will be very slow. So you be in pace with us. I will repeat time and again, because I do not want any mistake to be done by you on the basis of this memorization. If you can solve any question in your exam, it will be really great. 1 to 8 preliminary, 9 to 35 suits in general, execution 36 to 74, part 2. Part 3 I said incidental proceeding 75 to 78. Then I said suits in particular cases 79 to 88. Then particular cases के बाद special proceeding. Special कहाँ से शुरू होता है? Arbitration से. Arbitration, conciliation, judicial settlement, now mediation, ACJM 89. So that is 89 onwards. 89 onwards till 93. And what after special? It is supplemental proceedings. तो कितने पार्ट हो गए? पार्ट 1 में सूट्स इन जनरल था, 2 में एग्जीक्यूशन था, 3 देयर वाज इंसिडेंटल प्रोसीडिंग, 4 इट वाज पर्टिकुलर केसेस, 5 it is special proceeding. Is this clear? 5 it is special proceedings, and then 6 it is supplemental proceeding. तो 1 to 6 का आप एक ब्लॉक बनाओ. 1 to 6 का, because it is all related to suits trial. ध्यान दो मेरी बात पे. It is all related to suits and initial trial. Suits and initial trial. Try to understand. Suits and initial trial. ये सूट्स एंड इनिशियल ट्रायल से रिलेट करता है. आई एम नॉट इन हरी, यू बी केयरफुल. अभी तो मैं आपसे बहुत सारे सवाल पूछूंगा, क्योंकि मैं बहुत जगह ऐसा करूंगा जिसमें आप सतर्क नहीं रहोगे तो फिर मजा नहीं आएगा. सो व्हाट आई सेड, Part 1 to 6. Part 1 suit general. Part 2 execution. Then क्यों परेशान कर रहे हो? पर्टिकुलर. देन पर्टिकुलर के बाद बताओ, कोई बताएगा? सूट्स इन जनरल फर्स्ट, एग्जीक्यूशन सेकेंड, थर्ड वॉज इंसिडेंटल. अब यही देखो दिमाग काम करेगा आपका जैसे मेरा कर रहा है. यही हम लोग गलतियां करेंगे. दैट दिस इज देयर इन पार्ट 3, इंसिडेंटल, कमीशन, थर्ड पढ़ा था कुछ C3. तो हमेशा ये ध्यान रखना है. मैं आपको एक यहां पे छोटा सा फॉर्मूला बताता हूं. यू बी केयरफुल अबाउट दिस. IC3. IC3 आपको दिमाग में बिठा लेना. IC3 पार्ट 3 कमीशंस एंड इंसिडेंटल. ऐसे सवाल जनरली आते नहीं है, बट इफ दीज आर आस्क्ड यू बी केयरफुल अबाउट दैट. देन सूट्स इन पर्टिकुलर केसेस. सूट्स इन पर्टिकुलर, जनरल पहले आएगा या पर्टिकुलर पहले आएगा? आप खुद से सोचो. You do processing as much as you can do. Suits in general, suits in particular. So obviously suits in general will come first. So we have written general method first. So suits in general, execution, incidental proceedings. That's all. Over. वो एक भाग हो गया. This is one part. Suits in general, execution, incidental. Do it time and again, I tell you. If you are in a hurry, you can't remember. Then suits in particular, part 4. Obviously it will come thereafter, after general. So we have written general things before, three parts. Then it is part 4. Then suits in particular के बाद, suits in particular means 79 to 88. Then special. भी कुछ भी है उसके बाद जो भी आ रहा है 88 के बाद सूट्स इन पर्टिकुलर. देन स्पेशल. क्या है स्पेशल? जरा देखो, बताओ क्या है स्पेशल इसमें? स्पेशल प्रोसीडिंग्स. स्पेशल प्रोसीडिंग्स 89 to 93. एंड देन सप्लीमेंटल. नाउ अब मैं इसके डिटेल में थोड़ा जाऊंगा, थोड़ा सा डिटेल में जाऊंगा, बहुत ज्यादा तो नहीं. अभी बिगिनिंग है तो बहुत ज्यादा डिटेल में नहीं ले जाएंगे, सो दैट यू कैन नॉट नाउ कंज्यूम दैट. बट दिस मच शुड बी क्लियर टू यू. सप्लीमेंटल, this much should be clear to you. This is special is 5 and supplemental is 6. Is this clear till 95? अब आप इसको 10 बार ध्यान कर लो. पहले जनरल सूट आएगा, फिर एग्जीक्यूशन में जाएगा, उसमें कमीशन की व्यवस्था है. देन पर्टिकुलर सूट्स डिसाइड होगा, देन स्पेशल प्रोसीडिंग्स को देखा जाएगा, देन सप्लीमेंटल प्रोसीडिंग में आया जाएगा. आप अपने से कोई इस तरह का तारतम्यता बिठा लो और उसको ध्यान कर लो. आई होप यू कैन डू इट वेरी इजीली, बिकॉज पर्टिकुलर पहले आएगा, स्पेशल बाद में आएगा और सप्लीमेंटल उसके बाद. दिस इज इन क्रोनोलॉजी. पर्टिकुलर, स्पेशल, सप्लीमेंटल. इसके लिए कोई आप पूरा पैराग्राफ सेंटेंस भी बना सकते हो. 1 to 6 is over. Part 1 to 6. अब देखो part 7 onwards, if I see part 7 onwards, it is now either post trial or now as you read in CRPC, pre-trial, trial and post trial. Similarly, I can say it is post trial. Now once the trial has been completed in one court, then you go in appeal. Before that you cannot go in appeal. So order 7 onwards, order 7 is appeal, then reference, review, revision, this is also post trial process. Post trial process. 96 to 112. 113 to 115. Reference, review, revision. अब बहुत जल्दी मत रहो. Just understand slowly, coolly, calmly. Appeal, reference, review, revision. All right? Is this clear? 9 में हाई कोर्ट है, 10 में रूल्स हैं, 10 में जैसा आपने बताया कि 10 सेक्शंस दिख रहे हैं तो 11 सेक्शंस, but you can say 131 minus 121 is 10 sections. See, this memorization is to be done by you and me. It is not written in any book. So do it fast. And then last but not the least is rest of the sections, 132 to 158. 132 to 158. आप भी लिखो मेरे साथ साथ. Is this time I am writing very fast so that I am testing. No, this is not, this is not, this is not. एक भी गलती होगी तो पकड़ में आ जाएगा. Because I now remember. So that is what I expect from you. You do the same. You should not say later on that I don't remember. I will not listen that, my dear friend, from you. Particular, I said 79 to 88. Particular के बाद I have said special and then supplemental. These are three, these are three. You do it in part and part. If you do not do it in part and part, you will not be able to remember. And this may cost you dearly in your exam, because you may understand CPC very well, but you are not able to do it. Is this clear? ये तो आपको ध्यान है, पहला पार्ट ध्यान है तो ये ध्यान है. Is this clear? 9, this is also 9, see. This is how we can memorize. 3, 6 is 9. Is this clear? 3, 5 is 8. 3, 5 is 8. 3 plus 5, can you see this? You will have to do it yourself. Like I said in this, 9 to 11. So 74 is 11. Do it time and again. Don't be in hurry. I tell you, I am telling you time and again, those who are in hurry, now they will not be able to do justice to their understanding. Don't be in hurry. आपको लगता होगा, भ्रम होगा कि I remember everything, but you do not. When you will be asked, then you will be forgetting everything. 75 to 78, I said 78 minus 75 is 3, and this is commission, part 3. So you can little bit, now just make methods to memorize things. There is nothing great in it, it's very simple, but you can do it in your own way. Particular, special, supplemental. So exactly this is 10 sections. This is 5 sections. And this is 2 sections. अब देखो ये 10 sections exactly. 79 to 88 is 10. 89 to 93 is 5. And 94 to 92 is 2 sections. Do as much as exercise you can do. अब कुछ और भी तरीका सोचो. How to remember? Suits in general, execution, incidental. Particular, special, supplemental. Make it in blocks. You have done it, well and good. Now let us move further. Then I said, then we reach to appeal. So 95 we ended, so it will start from 96. A reference, a review, a revision. 3R, 113, and section is also 3. 3 sections, 3 things. 3 sections, 3 things. Do as much as exercise you can do. ठीक है? Then 116 to 120, 121 to 131, and then 132 to 158. What are the chapter names? Let us remember this. This is part 7. This is part 8. No? This is part 9. This is part 10. This is part 11. This is miscellaneous. Now miscellaneous comes always in the last. So no need to memorize. If you are memorizing, you are not doing justice. Miscellaneous comes always in the last. Just before that, rules. And just before that, I said the special provisions relating to High Court. So just pick up this point. So first 3 part were suits, execution, incidental, that is commission. Next 3 part were particular, special, supplemental. This is how a student should do. Then next few parts, that is 7 onwards till 11, that is 5 parts. First is appeal, second is the reference, review, revision, 3 sections, 3 things, 113 to 115, then High Court, 116 to 20, then rules 121 to 131. Now 10 sections in the sense that 131 minus 121 is 10 section. Equal to 10, but it is 11 sections. When it will be counted, it is 11 sections, mind you. Is this clear? I hope थोड़ा बहुत तो आप समझ गए होंगे. You will memorize this, no issue. Let me go a little deeper and further. I am coming to order also, don't worry. पहले order ही बता दें आपको, and then I'll go to many sub points. Let us do order first. Parties. Order 2, now parties will file what? Suit. So he will frame of suit. Then order 3, he will go to agents and pleaders. See, this is written in common sense way. Then these agents and pleaders will file the suit on his behalf. So this is what is called institution of suit. So we'll institute suit. Order 4. I am doing it again and again, I have done it earlier also. And then this institution of suit will lead to institution of suit will lead to issue of process. Issue of process. But before suit is instituted, we are required to follow the rules of order 6, order 7 and order 8 also. Order 8 as well. Why? 6 is in general pleading. This rule governs both Plaint and pleading. Plaint for plaintiff and written statement for defendant. So nothing great. So this is written in one block. Now you stop here. देखो हर चीज को आपने ग्रुप्स में ध्यान करना. You will have to memorize everything in groups. I will say the party will frame a suit or the party will initiate a suit. Through whom? Through recognized agent or pleader. So he will institute the suit. Lawyer will file the suit. You cannot go and you cannot file the suit on your own, because you do not have that legal competence and legal knowledge. Nobody prohibits you to file a suit as such, but it is always through a pleader. Wakalatnama, Vakil has to appear before the court. If court starts listening to everyone, everybody will reach to court with a complaint in his hand, and that is how the court will not be able to function properly. So there is due process. There is due process. A party who has grievance, he will now submit his grievance to a lawyer, and that lawyer will institute a suit in very common sense. The moment suit is instituted, other party will be called. So that is order 5, summons, issue of process. But before this is done, before the party is summoned, the proper filing of plaint now should be there. So for filing of plaint, you need to learn the law of pleading, that is order 6, and then you can file the plaint. And once summon is issued, and then the defendant will come with his written statement. So this is one part, order 1 to 8. आप अपनी भाषा में सीखो, ये बहुत simple है. You will understand it in legal way also after some time, but you understand it here in very general sense. Suppose I have a grievance. So obviously if I am not well versed in law and I am not a lawyer, I will knock the door of a lawyer. Then lawyer will listen to all your story, and then he will write the important points, relevant points, and then he will prepare a plaint. That is what is called drafting of plaint. In many examinations this is asked. So drafting of plaint has to be learned very carefully, because if you do not draft plaint carefully, then you will not be able to now tell the court what is the exact violation of your right, what is exact relief which you have in law and what we can give. And you cannot tell the court that you have jurisdiction, in this case pecuniary, territorial. So for all this reason, you need a competent lawyer, and that competent lawyer has to frame this plaint very, very well, draft this plaint very, very well. Because if you draft plaint wrongly, which may not disclose cause of action, which may not talk about the violation of right, which may not talk about the remedy exactly, which may not talk about the jurisdiction of court, then perhaps the court will not listen to you and it may result into negative things. We'll talk about that rejection of plaint and etc., etc. But you have to understand that if you have a grievance, it is always now advisable to approach through a person who has legal acumen, and that is what is the due process as well. So lawyer has to draft the plaint very well, following the rules of order 6 and order 7. Pleading's rule has to be followed. He should plead briefly, he should draft it para-wise, he should write everything in words as well as in digits, date, some amount, whatever it is. He should be able to tell the court that you have jurisdiction in this particular case, pecuniary as well as territorial. Otherwise, court will not entertain the petition, entertain the suit. So this is one part, order 1 to 8. Now the moment it is done, then I told you, then there will be now calling of the parties. So appearance, non-appearance. Appearance and non-appearance of the parties. That is order 9. Then examination of parties. Order 10. Is this clear? Now, once the suit is filed and both parties submit their plaint and written statement, then the court will call the parties, examine them. When the party will come, then only examination will follow. So, this is written in a structured manner, nothing great. Then there may be further queries. So, discovery, interrogatories, no? Something like that. You just see in your provisions, discovery and inspection. Discovery and inspection, order 1. Then the party may admit some claim, so admission, order 12. So these are all now collection of things before we proceed further. We collect all things before and then we frame the suit, then we frame the issue and then we hear the parties. Now you may remember even in CRPC, in Criminal Procedure Code, what happens? The police will bring all things before the court and then the court will frame the charge. Here there is no police as such. So it is the party's duties to bring before the court everything in advance. Just try to understand its common sense. In criminal law, it is duty of police to bring everything before the court. Accused has no duty because he is considered innocent till guilt is proved. So he has not been given any duty to bring any evidence before the court in criminal law. But civil law is not such. In civil law, it is A versus B. Both private parties are there. So private parties are required to produce everything in advance before the court. So you draft the plaint, annex the plaint with a document on which you want to rely, because you cannot travel beyond plaint in evidence stage. I'll tell you a little bit more about this when we progress further, that how plaint drafting is very, very important. If you do not draft plaint well, now you cannot travel beyond plaint in evidentiary stage. So you will have to mention everything at the starting itself. This is the biggest advantage which you will have. Though little bit correction is allowed by Order 6, Rule 17, amendment of pleading. But how much it will be allowed and how much not, now that is subjected to many ifs and buts. We are here to do complete justice, but does not mean that will allow you to do anything and everything. No. We are not going to do it. So discovery and inspection, admission. If I admit your claim, then there is no claim and court can decide it very easily and immediately. So that is why this kind of thing is allowed. Then impounding and production of document further, order 13. We are trying to bring everything before the court. Discovery and inspection is also meant for that. You bring some new facts, you bring some new things, no? Discovery. So this is all preparation stage before trial will begin. And then in order 14, this is impounding and production. We will understand all this when we move further, not here. My purpose is just to give you awareness right now. Time and again I am trying to do it because it is CPC, so you should find it well that you understand everything. Then when the matter are all there, then the settlement of issues. Now the court will settle the issues, order 14. You read it yourself as well, you will find that court will settle issues when everything is before the court. Then, first hearing. Now, here the case can be decided, but unfortunately, as I have told you, that this is not done in India. At first hearing, no suit is finally decided. But CPC contemplates a situation where there will be disposal of suit at the first hearing, but the people are here so now quarrelsome that they will never allow this to be done. So suit is not disposed at the first hearing, there is unlikely situation, disposal of the suit at the first hearing. When the suit is not decided, and then you summon witness. Then you call for evidence, summoning and attendance of witness. If he is confined in prison or jail, so that is why you order 16A. Because it is related to summoning of witness. So that is why we have added an order, order 16A, confined in jail, attendance of witness. Now, you may not be able to appear before the court for some reason or the other, and that is why there is provision of adjournment. But adjournment should not be allowed at the whims and fancies, and it should not be allowed again and again. Recently also Supreme Court has said certain things on adjournment, that this, and then evidence. Hearing of suit and examination, hearing and examination. Order 18. Order 18, then it says evidence can be given by affidavit also. Order 19. And then order 20, judgment and decrees. अब देखो ये जो आपने पढ़ा till this point, order 20. So order 1 to 20. Order 1 to 20 is related to 9 to 35B. 20A भी कह दो, cost. Judgment and decree will award the cost also, order 20A. 20A. Order, O for order, order 20A. And this is order 20. So again, see, this is a group. You should not travel beyond this right now. This is related to section 9 to 35B. I have already told you, now if you have to issue, or rather you have to file a plaint, then this plaint has to be filed as per order 7, order 6, order 4 and order 2. अब देखो plaint से related कितने orders हो गए, even order 1. अब देखो आपको ना थोड़ा धीरे धीरे अपने स्टैंडर्ड को रेज करना है. अभी तक तो हम बहुत बेसिक लेवल पे चल रहे थे. अब जैसे ही मैंने कहा आपसे यू हैव टू ना यू स्टार्ट फ्रॉम हियर. तो सीपीसी को कैसे समझते हैं? यू डोंट बी इन हरी. इफ यू वांट टू अंडरस्टैंड सीपीसी, फॉलो मी. सूट हैज टू बी फाइल्ड बाय प्लेंट. वेयर यू रोट दिस? सेक्शन 26. अब वेयर विल यू फाइल द सूट? So first you have to see that whether it is a civil suit, and this civil suit will be filed in a civil court. And if you go to court, then section 9 comes into picture. Now which civil court? Then you will talk of pecuniary jurisdiction. I will see jurisdiction. So jurisdiction are of various kind. This is also matter related to jurisdiction. This is subject matter jurisdiction. Then the pecuniary jurisdiction. Then there is another jurisdiction, territorial jurisdiction. Now you just try to understand again and again the same thing. Because everybody reads every topic, but they do not understand the whole picture of CPC. It's very simple. The moment a civil question comes, now my right to my property is violated. Somebody disposes me from my land, or somebody disposes me from my house. So obviously it's a civil wrong. Dispossession. So I will file a suit for getting the possession. I am saying in very brief and very raw language right now. I am not using any law as such. But I am asking you a question. Where will you go? Whether you file a suit in section 6 of SRA, where will you go? You will go to a civil court. SRA in that sense is also dealing with that substantive right. Procedure is prescribed in CPC because that's a civil wrong. But dispossession from property is also a civil wrong. So I will seek a civil remedy, because criminal remedy can punish somebody. Criminal remedy will not give my property back. Try to understand the point. So obviously I will go to civil court. I can file a criminal complaint also, but that's a different matter. I am not going into that. If he has used force, he assaulted me, he caused hurt against me, or whatever, or 145 for that matter, whatever, 145 of CRPC. I am not going into that question and I am not discussing that area right now. But I ask you a very simple question. If a party has promised now to do something under a contract and he does not, will you not file a suit for a specific performance? So where will you go? I will go to a civil court. So the moment you want to go to a civil court, you will have to file a civil suit. But to file a civil suit, you will have to file a plaint. And the moment you want to file a plaint, the question related to plaint will arise. But in that direction we will go. But here, now when you file a civil suit in a civil court, then you will see whether it is a civil suit or not first. So this is called subject matter jurisdiction. Subject matter jurisdiction. ये civil suit है या नहीं है, whether it is a criminal suit or criminal complaint or a civil suit. What is this? So here the question arises in section 9. If this is satisfied, then another question arises. Now there will be many hurdles at the outset, that whether this court has jurisdiction or not. Now which jurisdiction? So you say it is pecuniary, it is territorial. If I am evicted from my property in Delhi, should I go to Allahabad court or Prayagraj court? No. Should I go to Gurgaon? No. Why? This is unnecessary. This is common sense. This is common sense. Why I'll go? Now better evidence is here, court is here, execution will be simpler. You know, you just think simply. You don't go into legal tangles. I am not into that. I am not making it technical. I am asking very simple question. The property is here. Everything is here. Is it not easier for the court to get it executed here? Or is it not easier for the parties also to approach this court, which can have evidence easily, which can visit the site also, commissions can also be sent, whatever. And execution can be done easily if it is somewhere else. Now Delhi court cannot get it executed better. So just try to understand the point, that this is simpler, easier, if I file a case where the property is situated. And that is what section 16 of CPC says. अब देखो sections का खेल शुरू हो गया. So now these are the sections which confers jurisdiction on court. So territorial jurisdiction is conferred on court by section 16. What I said in the beginning, sections confer power and jurisdiction, whereas orders and rules prescribe the procedure. Power is here, procedure is there. So I don't think that you should have any kind of problem in understanding how these sections and how these orders are related. They are very much related. So I said, if I want to file a civil suit, first of all I will have to decide whether it is a civil suit or not. The moment I have come to this conclusion that yes, it is a civil suit, I will file a plaint. Now for filing a plaint, you have to see the procedures contained there in orders. Now which orders I tell you? Plaint content is written in order 7. The rules of filing this plaint is written in their order 6, because pleadings is there. So plaint is a pleading basically. So you have to follow the rules of pleading. But as you now institute a suit, so for better institution of suit, then there is order 4, which says that you have to comply with order 2 also for proper registration of suit. And order 2 deals with frame of suit, which says that, see, if you want to frame a suit, you have to claim whole relief, whole claim. And then you have to see that whether proper parties are added or not. So order 1, parties. So for filing a plaint, you will be reading order 7, order 6, order 4, order 2, order 1. So plaint में ही आप ये पांचों order देख लोगे. And plaint is mentioned in section 26, that you want to file a civil suit, you file it by filing a plaint. But plaint is to be filed in duplicate. अब देखो सेक्शन 26 में आपको पढ़ के सिखाता हूं। हाँ, अभी सवाल नहीं पूछना है आपको, सवाल पूछने से कोई फायदा नहीं है, अभी ये सब अपने आप क्लियर होगा। आप कुछ भी मत पूछिए, अभी धैर्य से बैठे रहिए चुपचाप। अननेसेसरी ग्रुप में लिखने से ना कंफ्यूजन क्रिएट होता है। सब कुछ भी नहीं है जो आप लिख रहे हैं ना, ये कुछ भी नहीं, ये सवाल ही नहीं है जो आप लिख रहे हो। डोंट राइट एनीथिंग इन ग्रुप प्लीज। आई नो व्हाट आई हैव टू आंसर, आपके कहने पे मैं बताऊंगा ऐसा नहीं है, तो इसलिए ना आप लिखे मत, कृपया छोड़ दें इसको बिल्कुल। सब अपने आप आएगा आपके कहने से। ये आप लोगों ने पिछली क्लास में बहुत ज्यादा किया और इसीलिए बहुत लोगों को कंफ्यूजन हुआ। हालांकि मैंने भी क्लास पूरा वॉच किया, मुझे तो क्लास बहुत ही अच्छा लगा, बट आप लोग इतना बीच में सवाल जवाब अनावश्यक करते रहे कि जैसे लगा कि छोटी छोटी चीज भी पहाड़ बन गया हो, एंड दैट वेस्ट लॉट ऑफ टाइम। So no question in between, question only towards the end. Please try to understand. और मैं आपको एक सीख देना चाहूंगा कि भाई जब भी कोई क्वेश्चन मन में आए तो पहले क्वेश्चन से जूझना सीखो। ऐसे ये सब तो कोई क्वेश्चन ही नहीं जो आप पूछ रहे हो, दिस इज नो क्वेश्चन एट ऑल। सो लेट मी टेल यू, हम सेक्शन 26 को पढ़ रहे हैं, एवरी सूट शैल बी इंस्टीट्यूट। अभी मैं ज्यूरिसडिक्शन तो पढ़ा नहीं रहा आपको, देखिए आपके क्वेश्चन अनावश्यक होते हैं, आप इस बात को मान लीजिए। दीज आर अननेसेसरी क्वेश्चन विच यू आर आस्किंग राइट नाउ, अननेसेसरी है ये सब। सो आई एम राइटिंग इट इन द ग्रुप, अननेसेसरी क्वेश्चन हैं ये, प्लीज अवॉइड दिस। ये अपने आप आएगा। अभी मैं ज्यूरिसडिक्शन आपको पढ़ा ही नहीं रहा हूं, आप बिना मतलब का दिमाग लगा रहे हैं। मैं अभी आपको ऑर्डर और सेक्शन समझा रहा हूं, आपको बहुत बारीकी से मेरी बात समझनी है। मैं ज्यूरिसडिक्शन अभी मैं ज्यूरिसडिक्शन पहले आपको पढ़ाऊंगा। आप तो जंप कर गए कि पिक्यूनरी और टेरिटोरियल बताओ सर, प्लीज क्लियर। जैसे लग रहा है आप सबसे सिंसियर है और हम सबसे इनसिंसियर है। आई डोंट टेक इट अदरवाइज, बट आई टेल यू दिस shows that you are not interested in what I am saying, you are interested in asking question. Don't do it for God's sake. You be a follower. एक विद्वान ने कहा, इफ यू वांट टू बी मास्टर ऑफ एनीथिंग बी ए ग्रेट फॉलोअर। बी ए ग्रेट फॉलोअर माय डियर फ्रेंड, इट विल हेल्प यू। आई विल टेल यू अबाउट ज्यूरिसडिक्शन फर्स्ट, एंड देन मैं बात करूंगा टेम्पररी, ये टेरिटोरियल एंड पिक्यूनरी एंड क्या होता है नहीं होता, मैं सब बताऊंगा आपको। इसलिए ये बचकाने वाले सवाल नहीं पूछने, ठीक है? तो ध्यान रखिए, इस आपका लाभ है, मेरा लाभ नहीं है कुछ भी। हाँ, मैं कुछ नहीं बता पाऊं, मेरे से कोई टॉपिक छूट जाए तो आपके पास समय होगा, लास्ट में आप मेरे से पूछेंगे, मैं बताऊंगा। अभी क्वेश्चन पूछने का मौका नहीं आया। अब जैसे किसी ने कहा कि सर ने डिक्टेशन नहीं दिया, भाई तुम्हें समझ कहां आ रही है, अभी डिक्टेशन का तो दौर ही नहीं आया, कितना समझाऊंगा आपको। आप धैर्य से बैठे रहो, शांति से बैठे रहो, बिल्कुल शांति से। मैं आपको एक एक चीज पढ़ा के जाऊंगा, मेरा वादा है आपसे, एक एक चीज पढ़ाऊंगा मैं, एक एक चीज। It's my promise. Don't write in the chat box, please. देखिए किसी विद्वान ने और लिख दिया, डिस्ट्रैक्शन होता है। नहीं, कोर और पेरीफेरी का यहां सवाल भी नहीं है। आप लोग कहीं से कहीं चले जाते हो, आप लोग बड़े विद्वान लोग हैं, मैं आप लोगों को अभी नहीं पकड़ पाऊंगा, बहुत मुश्किल है अभी पकड़ना आप लोगों को। बड़े विद्वान लोग हो आप लोग। कुछ भी मत लिखो चैट बॉक्स में, कुछ भी नहीं, नोबडी शुड राइट इट। कोर और पेरिफेरी कुछ नहीं होता, मैं अटमोस्ट कोर पढ़ा रहा हूं अभी। आप कोर और पेरिफेरी का मीनिंग बदल दोगे ऐसे लिख के। डोंट राइट एनीथिंग इन ग्रुप प्लीज। Every suit shall be instituted by presentation of plant or in such other manner as may be prescribed. कितना अच्छा लिखा है। तो होगा क्या ना कि चैट में लिखने से ना आप वही देखोगे, बैरक नहीं देखोगे। और मैं चैट देखना नहीं चाहता हूं बिल्कुल, मैं देखना चाहता हूं बैरक। तो कंसंट्रेशन भंग होगा आपका, यू विल बी डिस्ट्रैक्टेड मोर देन मी। सो एवरी, देखो एम्फेसिस, एवरी सूट शैल बी इंस्टीट्यूटेड, मैंडेटरी लैंग्वेज, एवरी shall be instituted by presentation of a plant. अब प्लेंट को कैसे प्रेजेंट करें? तो then you are directed to order 7. So section आपको खुद ब खुद, section is taking you to orders. Try to understand this point. Section is automatically moving you to orders. By presentation of plaint in such or in such other manner. Now then it says in every plaint fact shall be proved by affidavit. अब देखो मैंने लिखा every suit shall be instituted by presentation of plaint in duplicate or in any other manner prescribed by CPC to the court or such officer as appointed in that behalf, and the facts stated therein must be supported by affidavit. This section must be read with orders 4, 6 and 7. Primarily order 4, 6 and 7. But when you see order 4, it says that suits. No, अब देख लेते हैं, अब order को भी देखते हैं ना. आपको दिखाता हूं तब तो आपको पता चलेगा कि order section कैसे मिले हुए हैं. अब जैसे ही ऑर्डर 4 में आओगे ना आप, ऑर्डर 4 कहता है सूट टू बी कमेंस्ड बाय प्लेंट. Suit to be commenced by plaint. Every suit shall be instituted by presenting a plaint in duplicate. So order 4 says that it has to be presented in duplicate. Procedure बता दिया. You file plaint, but when you file plaint, you have to file it in duplicate. Then it says every plaint shall comply with the rules contained in order 6 and 7, so far as they are applicable. Order 6 talks of rules of pleading, how plaint should be written. So it should be written in, it should mention only facts, no evidence. It should be written in parawise form. Now everything should be written in very detail in the sense now specific averment should be there. There should be now a specific mention of what right, what relief you have. Now grounds to be pleaded specifically. Now everything has to be done specifically. Even if you claim limitation, exemption from limitation, that has to be specific. You have to talk about jurisdiction, you have to talk about everything. We'll talk about that in great detail. Now then it says, plaint shall not be duly instituted unless it complies with the requirements in sub-rule 1 and 2. So it says that if you do not comply with the order 6 and 7, then the plaint will not be considered duly instituted. So even if section 26 says that suit shall be filed by filing a complaint, suit shall be instituted by filing a complaint, filing a plaint. So how will you file the plaint? So order 4 says you have to file a plaint as per plaint drafted as per order 6 and 7. The moment you go to order 6 and 7, you realize that yes, it is not only order 6 and 7, it is also order 2. Because order 2 is one of the most important order in your examination, especially in Delhi. Order 2, rule 2. You have to make the whole claim, you have to claim the whole relief. आपको सब कुछ claim करना है, because splitting of claim is not allowed. You cannot file multiple suits on the same cause of action. No, no, no. I will talk about this again in great detail when I will come to order 2, rule 2. Is this clear? अभी नहीं पढ़ रहे हम उसको. But for proper framing of suit, order 2, rule 2 is must. Now, not only order 2, suit has many essentials. The parties, the cause of action. So even parties are important. So order 1. So that is why I said when you go to file a plaint, then order 1, order 2, order 4, order 6, order 7. All these 5 orders are important. But how suit will be instituted? Section 26 has said. But section 26 says only in one line. All the details are there in orders. So आपको कभी ये कोई कहे कि सेक्शंस इंपॉर्टेंट हैं, ऑर्डर्स नहीं, या कोई कहे कि ऑर्डर्स इंपॉर्टेंट हैं, सेक्शंस नहीं, तो दे आर जस्ट हैविंग हाफ हार्टेड नॉलेज. They are both important, they are supplementary and complementary to each other. You cannot read them in isolation. If you read CPC section wise, if you read CPC order wise, in both cases you are committing a blunder. You can never do it. So the moment I will start with the question of filing a plaint, I will read section 26 along with all these orders. but that will come little later. Now, the moment you have gone to institute a suit, I said you will comply with all these 5 orders. Where will you file this suit? So I said civil court. How do you know this? Section 9 says that. Now you read section 9. The court shall have jurisdiction to try all suits of a civil nature, excepting suits of which their cognizance is either expressly or impliedly barred. The court shall have jurisdiction to try all suits of civil nature, excepting suits of which their cognizance is either expressly or impliedly barred. All suits of civil nature. Section 9 very clearly says. So we know that with civil suit we can go to a civil court. But the question will arise, which civil court? So now the question of jurisdiction comes into the picture. Jurisdiction basically means the power or authority to decide a case. So a small court, again it's common sense, a small court cannot be given authority to decide case of huge value. You cannot give a case to civil judge junior division of 50 crores or 1000 crores. Generally it is not possible. It is not possible. Similarly in CRPC or in IPC, in criminal law, you do not give authority to lower judge to decide a murder case. This is common sense. Law is full of common sense. Only problem is that we are not able to appreciate common sense. That's our difficulty, our problem. So, and if I ask you another question, that if you want to file a civil suit, where should you go? The highest court or lowest court? So obviously you will say, I will go to a lowest court. So lowest court means court of lowest grade, competent court of lowest grade, that is written in section 15 of CPC. So there is nothing great in it. Before jumping into the area of jurisdiction, territorial jurisdiction for that matter, you should go to lowest court. Now which lowest court? And then the question of territorial jurisdiction arises. When I say value, then it is pecuniary jurisdiction. Pecuniary means money related, and territorial means territory related. So as I said, property is here from where I was dispossessed, or contract has been now here, everything has to be done in Delhi. Where will you file a suit for a specific performance? In Calcutta? Why? And if property is here, will you go to Chennai to file a case? Why? So you will file case here. This is what is called territorial jurisdiction. Territory. मैं आऊंगा इस पर section 16 to 20. But no, and another jurisdiction question comes. Pecuniary. What is the value of property? If the value is 100 crore, then you cannot go to now lowest judge. You have to go to the higher judge as per the jurisdiction prevailing in that state. In Delhi, if it is 100 crore, obviously High Court is the only remedy, because I think this court, district court has 2 crores jurisdiction. And this jurisdiction of pecuniary value or pecuniary jurisdiction will vary from state to state. State to state. Civil judge senior division in UP will have unlimited jurisdiction. But civil judge senior division in Delhi will not have unlimited jurisdiction. So that is the differences. And this is now as per the law, because this question of jurisdiction or generally of law of civil and criminal kind, they are all in concurrent list. On concurrent list, the state and the center both can make law. So this matter of jurisdiction of pecuniary kind is decided generally by different states differently. They have different standards. There are different standards in different states. Is this all right? different standards in different states. So I said you will see the question of pecuniary jurisdiction, you will see the question of territory. No, so what I understood that whenever I will read section 26, देखो ये सब ना नहीं बताने पे कुछ बच्चे तो खुद से समझ लेते हैं, but there are many people who will not appreciate this and they will remain always in confusion कि भाई ये order section क्या चल रहा है. So I will read it with order 1, order 2, order 4, order 6 and order 7. Now similarly, section 26 to section 29, summons is issued. So obviously I will read it with order 5. So now it will automatically tell you, that is what task I had given to you, that you please find which sections is related to which order. This is very interesting journey. It's very interesting exercise. Now, as section 9 to section 25 is dealing with basically jurisdiction matter, basically it deals with jurisdiction matter. Try to understand. So, you will not find that exactly in reading of section 9 or section 10 or section 11, you will need assistance of orders in general, because they deal with jurisdiction question, and jurisdiction is question of substance. This is written in sections itself. Orders will come where there is procedure. So the moment you want to institute a suit, procedure comes in picture. That by which method, by which kind of petition, by which kind of writing you will approach the court. So plaint, so how will you frame the plaint? So order 1, 2, 4, 6, 7. How will you issue summons? Summons can be issued by court as per section 27 to 29. But how will you issue summons? What kind of things will be written there? How it will be served? So that is in order 5. And there are various rules in order 5. Now you may ask a question, why there are so many rules? Like in execution, why we have 106 rules? Because execution can be done by various methods. Execution of various kind of properties. Execution of decree may be related to movable property, may be related to immovable property. If it is related to movable, then one method. If it is related to immovable, then another method. There can be sale, there can be other thing, there can be auction. So different things are written in execution. So there are various sections also, 36 to 74, and there are various rules. Though order is one, but there will be various rules, because see, there are so many sections, 39 sections in this part 2 of CPC. So why not 106 rules? So once you start analyzing these things, you try to now internalize the concept. Otherwise, if you are in great hurry and you start reading now jurisdiction, section 9, section 10, section 11, then you will not have grasp of CPC. So please be cool, calm, comfortable and try to understand this. Now, then this section 27 to 29 is summons. Then power to order discovery and like. So you saw that discovery is there in order 11. Summons to witness, that you saw that summoning of witness written there in order 17. 17 it is written, tell me. अरे बताओ कहाँ लिखा है? 16, जहां मैंने आपको बताया प्रिजन भी था. तो देखो अब याद करने का तरीका है, यू मेक वन वर्ड. यदि आपको, इफ यू वांट टू रिमेंबर द एंटायर ऑर्डर, यू मेक वन वर्ड ऑफ एवरी ऑर्डर. ऑर्डर 1 is party, 2 is suit framing, 3 is pleader, 4 is institution of suit institution, 5 is process, that is summons, etc. 6 is pleading, 7 is plaint, 8 is written statement, 9 is appearance, मैंने लिखा भी था, 10 is that examination, 11 is discovery, 12 is admission, 13 is production of document, 14 is settlement of issue, 15 is disposal at first hearing, 16 is witness, 17 is adjournment, 16 is also there, witnesses from prison, etc. Witnesses detained in prison, etc. 16A, because 16 is witness, so that then 17 is adjournment, 18 is evidence, 19 is affidavit, 20 is judgment decree, 20A is cost, 21 is execution. Now, order 21 is related to section 36 to 74. So that is what is the task to be done. अब मैं आ रहा था आगे, this you saw this jurisdiction, nothing much here because this is all substantive part. Then I said this power to order discovery, section 30. This is order 11. So you just do it yourself. Now many a times the book will not tell you all these things. Book is not going to tell you. So your reading method will not be sections in isolation or orders in isolation. अब बहुत सारे लोग नहीं समझते हैं. They will read entire CPC and then they will come and say, Sir, मुझे तो I could not understand how this section and how this order, how they are related. Arey, how can it happen? You have learnt it time and again in your class that it is so simple. Huh? So, summons to witness. Section 30. I'm just doing myself. I don't read it in any book as such. This is order. I said summons to witness. Oh, sorry. This is and this exercise will make your memory sharper. This is written witness and this is witness detained in prison. And I tell you, most of the questions you will solve like this in your preliminary examination at least. Most of the questions. You believe me or not. Judgment and decree, you have written in section 33. Judgment is written in order 20 and this is also written in order 20, I hope. देख लेते, just let us check. Nothing great in it. You do this first, you don't jump to the subject. You don't jump to the subject. I am cautioning you time and again. You listen to me or not, I am not sure, but I tell you, you don't jump. You may be in great hurry. Many people may be thinking कि सर अभी तीसरी क्लास हो गई, सर ने कुछ पढ़ाया नहीं. अरे सर ने जो तुम्हें पढ़ाया ना फर्स्ट 3 classes में, that is what is the art of success. You don't know this basically. Just reading books will not help you at all. No. That is a wrong notion. If otherwise everybody reads book, whole day you read book, but how much you retain? I said input, output. You have been reading for last so many years. Last so many years. Socrates said once that best method of learning is that you give question to students and you stop and stand till they solve the question. You don't answer the question, let them do it. And if they are able to do the questions themselves, that is the best learning which they have, because they exercise their mind too much and that is how you learn better. If you do not do, no, I want to do everything in the class in presence of you, because I want to learn as well, I want to memorize as well, I am doing the same exercise as you. I am a student like you in the class. But the only difference is that I am sincere and I am doing it, but I don't know how many of you are doing it. Many of you may not be doing it, but that is where you commit blunder. Have a pen, have a copy, have a paper, do it yourself. Your hand should do it. Your mind should think it. It should not happen that I should think it. Now, students will ask me for answers. I can give you answers of everything in advance, but that is the most nonsensical thing which I will be doing. Most nonsensical. It may gladden your heart sometime, but that is really foolish, I tell you. You do solve the question, and wherever you do not solve the question, or where you are not able to solve the question, then you ask me. If you ask me everything, I will answer everything. Then what is you doing, my dear friend? You are not working upon. So sit at home, do all this exercise which I am doing here. It is not to be read in the books. If you start reading the books, then you are now following the book's knowledge, information. You exercise upon your mind. ये मुल्ला साहब ने अपनी किताब में नहीं लिखी जो मैं लिख रहा हूं यहां बैठ के, नहीं नहीं नहीं, उन्होंने आई एम इनोवेटिंग माई सेल्फ, एंड एजुकेशन इज ऑल अबाउट इनोवेशन. दैट इज व्हाट अल्बर्ट आइंस्टीन सेड. नाउ education is not the learning of facts, it is rather the training of mind to think. So my job is training of the mind to think, that how you can think. Now see, I progress little further. I am training you to think properly. You said interest, you said cost. So we read about cost. Cost is written here in section 35 to 35b. And there it is, cost is written in order 20A. So this will be read along with this. Otherwise, you understood the first part, suits in general. Suits in general, you understood which order to be seen. Of course. Now, when you try the suit, have you written this? If you have written this, let me tell you a little further. When you file a suit in section 26 with the help of plaint and with the help of order 1, 2, 4, 5, 6, 7. The moment suit is filed, summons will be issued. Section 27 to section 29. And this will be read with order 5. Then the written statement will be filed by the other party. Then order 8 comes in picture, read with the order 6, obviously pleading. Once the written statement is filed, then in filing of suit by plaint and in written statement, in both cases we have to see that we have followed all the rules of this order 1, 2. So parties are always important, so that you have to take care of. It's very, very important. Order 1, order 2, order 4, order 6, order 7. These are important at this stage. So you have done all this. Now, then the parties will be called, appearance and non-appearance of the parties, that you have read in order 9. Alright? Then you examine the parties. This you do in criminal procedure also. The moment this police will file evidence, police will file charge sheet, then the other party will be called, summons will be issued, and then the other party will come, the charge will be explained to them, and now charge will be framed and explained, and then the trial begins. So similarly here, after all this is done, then there is appearance and non-appearance of the parties in order 9, and then examination in order 10, then discovery and inspection in order 11, that is read with interrogatories, you may ask questions. Then order 12, the parties may admit, there also it is plea guilty in CRPC, here you can also admit order 12. And then production and impounding of document order 13, then settlement of issue, and then 15 disposal. So, at the first hearing. But if it is not done, then you call the witnesses. So trial begins after the settlement of issue. When the trial begins, my dear friend, I tell you, when the trial begins, then obviously in trial many processes come in between. Many processes come in between. What are these processes? So these are entry orders also. There can be substitution of parties also, order 22. Now these trials are general trials. When you try a special suit, then the special procedure will apply. So I just tell you, my dear friend, further, for memorizing of this orders, that see, substitution or transfer of parties. Now one party is not there, he is dead, etc. This is written in order 22. Substitution of parties. Can you see this in order 22? Execution of decree, order 21, you have come to know. So death, marriage and insolvency of parties, order 22. This is clear? Nothing great? Nothing great? One party has died, another has to be substituted. Somebody's father died, so the son will come as legal representative. Withdrawal and adjustment of suit. Withdrawal and adjustment of suit. You can withdraw the suit, you can now adjust the suit. That is order 23. Certain payments can be asked in the court. Defendant are asked to pay in the court sometimes. You will have to do this. ये अपने आप में करो. No, नहीं हो तो you stand before a mirror and you just try to explain how this CPC progresses further. You don't be in hurry. Section 9 या section 10 या section 11 का 4 पेज का notes बनाओ. You can make a beautiful notes and you can memorize certain points and you can reproduce them in exam. It's not a great learning, I tell you, and many people become judge like this also, but they never understand the soul and heart of the act. And that is why they are not so interested in their decision making process, and they are not very happy about the work they are doing because they do not understand. Though they have read and they have become a judge, but they do not understand exactly. It can happen to me also, it can happen to you as well. It should not happen to us. That is why we are required to train our mind to think properly. So I said there can be substitution of suit or substitution of parties, not substitution of suit exactly. And then withdrawal and adjustment. अब देखो ये सब ना तुम्हें ध्यान करना है. Payment into court, security for cost, and then commissions. अब order 21 to 21 तो you remember. Order 22, order 23, order 24, order 25, order 26. So ये तो substitution, transfer I said. Substitution of parties, death or marriage or etc. ये withdrawal or substitution of parties. Withdrawal or adjustment of suit. Payment into court. Can you see this? Security for cost. Now suppose tomorrow you may run away from this place and we may not be able to claim the cost which is involved in the suit. So how will we now security for cost may be required from plaintiff. Plaintiff may have filed a frivolous suit, vexatious suit, unnecessary suit. Many people have unnecessary complaint. You have seen this or not? आप देखेंगे नहीं, बहुत लोगों को unnecessary, बहुत लोगों को लाइफ में complain ही रहता है. They will always be complaining. This region, that region, this region, that region. Even some students inculcate this habit of complaining. Unnecessary they will complain. Unnecessary. But this is not going to help. Let us be positive. We can complain, we should complain to ourselves as well and to others as well. I will complain to you, you will complain to me. But always complain, मटेरियल नहीं मिला तो कंप्लेन, क्वेश्चन नहीं मिला तो कंप्लेन, कॉपी नहीं मिली तो कंप्लेन, क्लास नहीं चल रही तो कंप्लेन, एवरीवेयर, वीडियो क्लास चला तो कंप्लेन, एवरीवेयर कंप्लेन, दे हैव कंप्लेन ऑलवेज. So maybe a plaintiff may be there who may not be interested in real prosecution of the suit. He is interested in false, vexatious, frivolous suit being brought to the court. And suppose he runs tomorrow, what will you do? So that is why we have security for cost from plaintiff. Order 26, I said commissions. देखो, these things will happen in between. Parties will be substituted in any trial process. Adjustment of suit can be done in any trial. Payment into court, court can ask always defendant that you please pay the money in advance because it seems to be prima facie justified. We'll decide this case later on, but you give money first. You will see even in a criminal procedure, in many cases of cheating, etc., court will demand first that you pay this much money, otherwise we are not going to allow you the bail, etc., something like that. Security for cost, commissions may be sent by the court to different places because court cannot go everywhere. So order 26 said we read with section 75 to section 78, that is part 3 of CPC. Order 26, commissions. Now this is general. Not only this, I tell you my dear friend, अब देखो ये तो बिल्कुल अलग है, but these three are called interim orders. Here you will go to substitution, that's a different matter. The main person is dead and legal representative will file an application for substitution of parties. And it is always your right as in civil suit as a private party that you can withdraw or adjust your suit. That's not at all an issue. It can be done at any stage before judgment. But payment into court can be asked by the court as interim order, security for cost as interim order, and commissions. So that is how we remember 25 to 26 as PSC. P for payment, S for security, C for commission. PSC. बिना सवाल पूछे नहीं रहा जाता है आप लोगों को, नहीं? ऑल राइट. भाई एफिडेविट से एविडेंस देते हो तो बता ही दिया, इसमें पूछने क्या बात है? 26(2) से क्या करना है इसमें? एफिडेविट से एविडेंस दिया जाता है, या जब प्लेंट फाइल करते हैं तो वो भी एफिडेविट लगाते हैं, तो एफिडेविट एविडेंस होता है वहां. नाउ अभी पढ़ेंगे हम लोग एफिडेविट एविडेंस के बारे में. मैंने बताया आपको ऑर्डर 19, हम लोग आएंगे उस पर बार बार, आपको कोई पूछने की जरूरत नहीं है, डोंट वरी. तो 24 to 20, और ऐसे जो भी सवाल हो ना क्लास के लास्ट में से पूछिएगा. हाँ, 24, 25, 26 PSC, पेमेंट इनटू कोर्ट, सिक्योरिटी फॉर कॉस्ट, कमीशंस. अब देखो ऑर्डर 27 to 37, दीज आर पर्टिकुलर सूट्स. तो ये अभी हम लोग देखते हैं पर्टिकुलर सूट्स. मुझे लगता है काफी लंबा समय ले लिया, 5 मिनट का ब्रेक ले लेते हैं, देन विल बिगिन अगेन. मुझे और भी चीजें बतानी है आपको. सो वी टेक 5 minutes ब्रेक प्लीज, देन विल बिगिन अगेन. ऑल राइट. So PSC payment into court, security for cost and commission. See, SC you can remember, and PC and C. So PSC, PC payment into court, security of cost and commissions. PSC 24, 25, 26. अब भाई बार बार now one friend will ask another friend PSC क्या होता है, what is PSC? So one will say payment into court, security for cost and commissions. So that is how you can memorize. You will have to do all this output. Is this clear? Before I proceed further, I must tell you should not be disturbed by the fact that questions, even if it is so that it is not answered by the teacher, you have time towards the end of the class, number one. And number two, I have given you time of 9 to 9:30 in the morning. Those who do not know, for them I wish to make them clear about this. 9 to 9:30 in the morning and 9 to 9:30 in the evening. You can ask your queries in the group, WhatsApp group. If you want me to answer the question or teachers to answer the question, don't write too much, write questions very clearly, referring to the question number of material and page number of material. We will answer that question in the class, don't worry. And towards the end of the class, you can always ask the question. So don't worry at all. And give time to the teacher to answer the question and to teach the whole topic. Because if you write too much in chat box, that is not going to help, it is worsen the situation. It creates problem for all. Too much writing in chat really creates confusion, I tell you. This is what you did last time. Though many people are new in this class, I hope they will have clean slate. And the people who are in the class, even before, they will also understand it, it is for their betterment. No question will remain unanswered. But don't unnecessarily raise every question. अब जैसे आप बहुत ही ट्रिवियल सवाल भी पूछने लगते हो कभी कभी, ट्रिवियल सवाल मत पूछो, वो हम खुद ब खुद पढ़ाने में ना एक एक चीज बताएंगे आपको. हाँ, यदि कभी मुझसे कोई छूट जाता है, आई एम ए ह्यूमन बीइंग, प्लीज रिमाइंड मी, आई विल आंसर इट अगेन. इज दिस क्लियर? जितना पढ़ा रहा हूं उतने को आपको फॉलो करना है. बहुत ज्यादा भागना नहीं है इधर उधर, और बहुत ज्यादा बम्बार्डमेंट स्टार्टिंग से करोगे तो इट विल क्रिएट प्रॉब्लम फॉर योरसेल्फ. सो डोंट बम्बार्ड योरसेल्फ विद इंफॉर्मेशन. गो स्लो and go very systematically and use this as much as you can, because if you answer the question, it's always, see, answers are there in your material, there in your barrack. 99% questions are there answered. So unnecessarily poking and asking the teacher to make your task easy, which is really cumbersome for you, because you will never understand then. Because education, I said education is basically training the mind to think. So my job is to train you to think properly. And for this, I will request you to watch the lectures or short videos of your topper. You are a student of Ambition Law Institute, which is proud institute to produce so many successful students. Recently, Gujarat and Chhattisgarh, both places, our toppers are there, and they have uploaded their 10 minutes, 15 minutes video on YouTube, which is interviewed by this one or that one. So you just listen to them what they said. Even you can listen to the interview of Akanksha Tiwari, UP topper. UP judiciary topper. So you will understand what they do. They do not do, they're very ordinary student. I tell you, I was not able to recognize them properly before they became topper. And they used to do all those things which you are doing right now. But only difference is that they followed the advice very seriously. Read little, but read it 10 times, 20 times. Consolidation is very important. Output is very important. आप चाहते हैं हम आपको बम्बार्ड कर दें जैसे यूनिवर्सिटी में होता है और उसके बाद आपका आउटपुट जीरो हो जाएगा. So you read little, but you read very very carefully. आज जो मैंने पढ़ाया वो आपके दिमाग में बिल्कुल बैठ जाना चाहिए. मैंने इतनी बार बताया आपको ऑर्डर 1 to 21 कैसे याद करेंगे. I told you several times, section 26 has to be read with order 1, order 2, order 4, order 5, order 6, order 7, not 5, order 4, order 6, order 7. So you should remember along with section 26 5 orders मुझे पढ़ने हैं. अब आपको मेंस एग्जाम भी आएगा. If you are writing this question on 26, you will remember, oh, 5 orders are there. Even if you happen to remember little bit of those 5 orders and you happen to write, your work is done. Plenty you are drafting, you happen to remember all these 5 orders. Oh, I have read it 10 times in class itself and then 10 times myself. So, plenty ke drafting mein I know order 6, order 7, order 4, order 2, order 1 is important. So, I have to see these 5 orders in drafting of plenty. So, you will be able to draft little bit better than others. So, concentrate on what you have. You do not look for things beyond. Then you will become a researcher. If you want to be a researcher, that's welcome. You will make me learn more and you will learn also better. But if you want to pass the examination, you are not required to become a researcher. You be a good follower, you follow the advice. So questions will, and some people have some questions which I got from my office. भाई सर डिक्टेशन नहीं दिए, सर डिक्टेशन नहीं देते. अभी हम डिक्टेशन अभी पढ़ा कहाँ रहे हैं आपको? अभी तो मैं पढ़ाना शुरू भी नहीं किया, ढंग से शुरू नहीं किया. इन द सेंस दैट आई एम नॉट टीचिंग एनी टॉपिक ऑफ डिक्टेशन. We'll be doing it, don't worry. Is this clear? Is this all right? So don't be in hurry, be cool, calm, patient, and try to listen to me carefully so that we can have better results, wonderful result. I will tell you what are the important things, what are the important matters. So questions I have told you. Now then let us proceed further. अब देखो अब आप आ गए स्पेशल सूट्स में. जनरल सूट्स यू हैव ऑलरेडी रेड. ओहो, no, let me tell you even before this. Execution, section 36 to 74 read with order 21. And then 22 to 26 you have already read. Commissions you have already seen part 3 of CPC. Now comes part 4. Particular cases. Now what are there in particular cases, suits in particular cases? So you just see suits in particular cases. This is very interesting exercise. Do it at home also. I am doing it, so I am learning it better. You do it, you will learn it better. Now see, suits by or against the government. Suits by or against the government. Section 89, notice 80. Suits by aliens or by foreign rulers. नहीं, 83 to, this is 83, not 82, 83 to 87A. Clear? And then former Indian states. There were former Indian states like Hyderabad and Junagadh and this and that. This is 87B. And interpleader, I'll tell you. Interpleader will equal interpleader law. This is section 88. Now, this is particular cases. Now you see the orders. Now you have read till 26, you remember that. Now orders also of section 27 to 37 are special orders. So see, order 27, suit by or against the government. Can you see this? So this is to be read with order 27. And this is also related to this, suit by or against government. So 2 months notice is must. Is this clear? Is this all right? Substantial question of law. अब इससे related कोई है नहीं, इससे related कोई है नहीं. There may not be requirement of procedure, it's very simple. Generally you follow all those things. And 88, this is order 35. This is 35. Interpleader suit. 3 plus 5 equal to 8. And 8 and 8, 88. Now what is in between? What is in between? 27 we wrote, 35 we wrote. What is in between? So let us see what is in between and how to memorize them. How to memorize them. Order 27A, 28, 29, 30, 31, 32. Let's see how we can memorize this. 32A. अब बाद में हमसे भी आप पूछेंगे और मैं आपसे पूछूंगा किस ऑर्डर में क्या है. Who can give immediate answer? I will see it. 33 and then 34. Is this clear? 35 we have already seen. And then this 36. Clear? 27A substantial question. Government related substantial question of law as to the interpretation of question. Now you know this. Generally, we read this in Constitution. (28) 28 is suit relating to military. Air Force. Now have you read IPC? You must have read. Offences against state there in chapter 6. And the chapter 7 is offences against military, air force, navy, etc. Is this clear? Then this, so government and then military, air force, that is clear? That is clear. भाई देखो अब ये जनरल सूट नहीं है, अब कॉर्पोरेशन के खिलाफ सूट होगा तो उसमें क्या करोगे, इसीलिए बताने की जरूरत है. Firm or carrying firm in name of other than their own, suit by or against firms. So one word, firm. 31, trustee, executive, administrator. 3. That is how you can remember trustee, executive, administrator. Then suit by or against minor. Unsound. 32A, family. (33) indecent. Corporation, firm, T, minor, family, indecent. Then 34 mortgage. ये सब देखो स्पेशल सूट से, अभी आपको लग रहा होगा ना बड़ा कठिन है, मैं बताता हूं बहुत आसान है. ये बताई दी आपको इंटरप्लीडर. और 36 इज फ्रेंडली सूट. You have read section 90, it is related to this. Section 88 is related to this. अब देखो आप शुरुआत से चलो, 21 तक तो आपका क्लियर था. 22 to 26 you said this is interim provision. Now rather basically 24, 25, 26 is interim provision, 22, 23 general provision. 22 talks of substitution of parties, transfer of parties in case of death, marriage, etc., etc., insolvency. 23 you said you can withdraw or adjust your suit. 24, 5, 6 I said PSC. Payment into court, security for cost and last commissions. Then 27 onwards I said it is a special suit. 37 रह गया ना? So 37, let me write it 37. 37 is, बोर्ड में इतना एक प्रॉब्लम हो रहा है लिखने में. 37. is basically summary suit. I tell you how to memorize this. So 22 to 26 you remember. 27 I said suit by government or suit by or against government. That is what you read in section 79 there. Notice has to be given to government in 80. Then 79 to 85 is suit by or against government. 85B suit against that former Indian states. Now something like that, कुछ ऐसा ही है ना? देख लेते हैं भैया, ऐसे ही याद होता है. Whenever you have some kind of memory loss, you just see that. 85 तो वो है, 87, 87A foreign state and ruler definitions. And then 87B is former Indian states. 87B is former Indian states. All right. So that you read 79, 80 is related to order 27. 27 is substantial question of law, state and substantial, you can relate little bit. 28 is military, air force, navy. Then you have seen that there is corporation, there is firm, there is minor, unsound, then there is family. अब उसको एक क्रम में डालना है. Corporation, firm, T, trustee, executive, administrator, minor, unsound, family, indigent. These are all special cases. Mortgage interpleader. So just you are required to think little bit which kind of special cases are there in 27 to 37. So first and foremost, government. Government is protected by military, army, navy. Our country is protected by army, navy, air force. So 28 is that. 28 is that. In between, substantial question of law. Now then, CFT. आप कुछ ना कुछ तो बनाओगे ना. CFT. Minor will become major, he will create a family, and if he doesn't run family very well, he will become indigent. The moment he will become indigent, he will mortgage his property. Something like that. Minor will become major, he will create a family. So that you can remember easily, I hope so. Minor की ही family होगी आगे. And family होने के बाद indigent होने की संभावना रहती है. There is possibility of being indigent because he will waste so much money. So minor, family, indigent. Minor will make a family tomorrow. And when you have family, then there is possibility of being indigent because you will spend so much, wasteful expenditure. And the moment you become indigent, then you will mortgage your property. So, from where you started? You started from government, then military, navy, government is protected by them, then corporation, firm, minor, corporation, firm, trustee, executive, administrator, CFT. Then minor, family, indigent. I said minor will make a family and if he doesn't run family well, he will become indigent and after becoming indigent, he will mortgage his property to get loan, etc. Dispute will arise, so he will go for interpleader. ये वाइफ का है या आपका है उसका है या इसका है ना. When there is dispute regarding this claim that it is whose, then interpleader suit. Interpleader suit. नहीं? Interpleader suit. And after interpleader suit 36. F is, I hope, 6th alphabet of English. 36 F. As per 7, as per summary. And that is how I remember. You can also remember. And now this is 6th alphabet. F is 6th alphabet. As for 7, 37, and as for summary. Summary means now the suit which is decided quickly. Summary, money suits. 6 for friendly suits and 37. Now, after this, you remember it always block-wise. You remember 1 to 21, one block. Then you remember this 20 to 23 substitution of parties, withdrawal, adjustment. Then you remember that there is this interim orders, PSC, payment into court, security for cost, 24, 25. And then last but not the least, commission, PSC. Then 27 is government suit by or against government. Then 27A is that substantial question of law as to interpretation of constitution, etc. Then military, navy, air force. Then this corporation, CFT. Then the firm, order 30. Then trustee, executive and administrator, that is 31. Then minor, unsound, that is 32. Family, A for family, A, 32, a family. When minor will become adult, he will make a family. And after making family, if he doesn't run properly, if he doesn't do his business properly, then there is always chance of becoming indigent, order 33. If he become indigent, then he will mortgage his property. Then there will be interpleader suit which will decide it is whose property, wife's property, husband's property, this property, that property, interpleader suit. When there are two persons claiming the right over the property or the ownership of property, then there is interpleader suit. Something like that. Then I said 6F, friendly suit, and 7, summary, 37, summary. So that is how you can remember. 27 to 37 is one block, 24 to 26 is another block, 22 to 23 is another block. Now you read further, interim orders, 38, 39 and 40, I tell you how. 38, 39 and 40. It is attachment or arrest before judgment, no? Before judgment, after judgment, so that is in execution. It is interim order. It is during trial, arrest and attachment. He will run away, he will sell his property, so attach his property before, arrest him before. 39 is injunctions. Temporary injunction, order 39, and 40 is receiver. So now how I will remember this? I will remember it AIR. All India Reporter or All India Radio. A for arrest and attachment, I for injunction, R for receiver. So बहुत सारे फॉर्मूले बनाएंगे. I said PSC 24, 25, 26. वहां भी बनाया हमने CFT, corporation, firm, T, that is trustee, executive, administrator. Minor, family, indigent, mortgage. So just see this, how it can be done. This was 29, this is 30, this is 31, this is 32, this is 32A, this is 33. So you will have to make some arrangement like this, otherwise you can't help it. कुछ और सोचो, you think further, you can do wonders. I can tell you many more methods as we progress further, but to begin with, I give you hint that see, relate sections with order, don't read them in isolation, section 1 and order, this cannot be done, it's useless. It has to be read in combination. Like now, if we do not sit together, if you do not discuss the point with me, how can I help you? If you do not read them both in conjunction, how can you do it? Obviously, sections are substantive, rules are procedural, so if there is any conflict, sections will prevail. But it is our task to read them harmoniously, read them in combination, read them in conjunction. Is this clear? Now, see, if you have done all this, you read the general suit 1 to 21, then suit in general, that is 1 to 20, then execution 21, then you read about substitution, withdrawal and adjustment, then payment into court, then security for cost, then commission, then government, then this substantial question, then military, then this corporation, firm, trustee, executive, administrator, then minor, then family, then indigent, then mortgage, then this interpleader, no, interpleader is 33. 33 is interpleader, then this, 33 is indigent, and then this mortgage is 34, then interpleader is 35, and friendly is 36, and then this summary suit is 37. Then now in this entry orders, I said AIR, that is 38 is arrest and attachment, 39 is injunction, and 40 is receiver. Is this all right? 40 is receiver. Now then, we have to start from 41. This is the last part now. You will remember AIR, you will remember CFT, you will remember PSC, and you will remember these are entry orders. This and this. These two are entry orders. AIR and PSC are entry orders. अब देखो इसी से याद करो, 6 ऑर्डर तो यही आर एंट्री ऑर्डर्स. Now what is AIR, what is PSC? अब एक दूसरे से पूछो. This is how you can make your memory faster. What is CFT? You ask yourself, what is CFT? Question बनाओ. What is MFI? Question बनाओ. You frame question like this, that is how you can memorize. There is technique to memorize. People will remember lakhs of digits. Why not we? Why to be afraid? Let us evolve some methodology to remember. Now if I ask you a question, what is CFT? You should be able to tell me. That sir, it is nothing but order 29, 30, 31. I'll be happy. What is MFI? It is nothing but order 32, 32 and 33. So this is how we can memorize things better. 34 is mortgage and 35 is interpleader and 36 is friendly and 37 is summary. So you should be able to do it. What is AIR and PSC? What is CFT? What is MFI? What is PSC? This is how we can do it. Is this clear? Where is cost? Order for cost 20A, because that is related to judgment. This is another kind of cost here. Payment into court and security for cost. This is security. So no confusion, it is security for cost. Now for getting cost from plaintiff, we get security in advance. That is what is order 25. So is this all right? Now let us proceed further. Order 41 onwards. We'll see how we can do it. Now it says appeal. So appeal, all right. Appeal from order. 41 is appeal from original decree. 42 is appeal from appellate decree and 43 is appeal from order. 44 is appeal by indigent. 45 is appeal to Supreme Court. So see, this is appeal provision. 96 to 112. You know this? So appeal from decree. Appeal from appellate decree. Appeal from order. Appeal by indigent. Appeal to Supreme Court. Is this clear? Appeal to Supreme Court. Appeal to Supreme Court. Then as you read there, reference, review, revision. So reference review has this. Reference you read under section 13 and this under section 114. Sections and orders. That you do at home again and again. Order 48, miscellaneous. Miscellaneous is always in the end. There also you found miscellaneous 132 onwards till 158. 132 to 158. Then High Court. This was in part 9 there, if you remember correctly. And 50 is provincial and then presidency. Provincial Small Cause Court Act. Small Cause Court. And this is presidency. SCC. Appeal के बाद there also it was reference. 112, then there was reference. Here also in order it is after appeal reference. Then after reference there was review. So here also review. There is no order for revision. There is no order for revision. Then miscellaneous, then High Court, then provincial, then presidency. Last part 48 to 51. भी देखो याद करने का, appeal is from order 41 to 45. Now I have refreshed my memory. After long time I will remember it for long time now. 41 to 45 appeal, 96 to 112 appeal. 113 there, reference here 46. Review 47. There it was 114. Reference, review, revision. Revision does not have any order as such. And then miscellaneous order 48. Then High Court, Chartered High Court 49. Then provincial SCC, Small Cause Court, that is 50. Presidency is 51. Now after then you can see this appendix also. There are now H appendix, H. So 8 appendix. There were 5 schedules, but there are no 5 schedules, there is only 1 schedule right now. Then there is glossary in your Bear Act given by us 363 onwards. Is this clear? Is this all right? So see how appendix is written, I must tell you again. It's very simple, very general. Very general. Pleadings, process, discovery, decree, execution, supplemental, appeal, reference. Now see, this is not written in a great way. Pleadings comes first. If you do not file the pleadings plan, then can you issue the process? No. As it is written in order, discovery, inspection and admission will follow thereafter. Then only judgment can be given. So decree is thereafter. And decree is given, then only execution. D for decree, D for appendix, E for execution, E for appendix. A is first, that is pleadings. B is process. C is discovery, inspection, admission. D is discovery, D is decree, E is execution, F is supplemental processing. See the skeleton of section, supplemental is written in 94, 95. And then appeal, reference review. So G is appeal, reference review. H is miscellaneous. So 8 parts. I don't think that you will find much problem. Pleading will be there, then the process will be issued. Then discovery will be done, inspection. This is what is written in order before. Then decree will be passed. Then execution will be done. So you remember it like this. This is clear. E for execution, D for decree. So obviously this is C, this is B, this is A. A, B, C, D, E. 8 parts. And then rest 3 parts is regarding appeal, a reference review, no, appeal, reference review. So this is F, E के बाद F. Then no. Before that, this is appeal is G. Appeal reference review. So we can remember it like this: ARG or AGR or GAR or something like that. But this is not required to be remembered because appendix is not going to be asked in examination. But I just tell you the method. First five is very easy. Then supplemental is 6. Appeal reference review is 7th, and the last but not the least miscellaneous. So this is how I think that you can progress further. Now again we will start our journey from beginning of a civil suit. When we go to file civil suit, what kind of hurdles we face, how the hurdle of hurdle will begin. If we go to file a civil suit in court, there are many hurdles at the outset. Which court to go first hurdle? If you decide the civil court, then which pecuniary jurisdiction, which territorial jurisdiction, so that is what is to be followed. And then how will you approach the court? By plaint, by pleadings, how will you write plaint, how will you write pleadings? Then how will you file a statement, how will you issue process? Many hurdles are there. So we'll read it block wise. We'll start from the beginning, section 9. So then how will we write plaint, etc. I'll tell you what is the plaint drafting and how it is done. So I think for today it is enough. So again tomorrow we'll start our journey of CPC. Be cool, calm, I'll give you all, whatever is required for your exam. If you do not apply your mind, that will be better, I hope. Let my mind apply in all these things, and then you just answer the questions, you solve the questions, you write the answers, you raise the questions also. Yes, please, why not? But let me address the questions first, then you raise the questions. Is this clear? So thank you very much. If you have any doubt, dispute right now, though it should not be, but even then if you have any doubt, any question, any query, any concern, please let me address. I am here to address your concerns and questions, please. प्रतीक जी जो पढ़ा रहे हैं उस पर चर्चा करिए, यही सब मेरे को अभी कहाँ आप जा रहे हैं शब्दों के चक्कर में, हाँ इसके लिए डिक्शनरी हम लोगों ने एक बनाया हुआ है. व्हाट इज पार्ट 1 to 6 इन सूट, ये क्या है? पार्ट 1 to 6 सूट इन, ये क्या लिखा है आपने? मुझे नहीं समझ में आया सवाल आपका. पार्ट 1 to 6 सूट इन, ये क्या हो गया? सूट से रिलेटेड होगा. यू जस्ट सी बेयर एक्ट. पार्ट 1 में सूट्स इन जनरल है, पार्ट 2 में एग्जीक्यूशन है, पार्ट 3 में इंसिडेंटल प्रोसीडिंग है, पार्ट 4 में पर्टिकुलर सूट्स हैं, पार्ट 5 में भी स्पेशल प्रोसीडिंग है और पार्ट 6 में सप्लीमेंटल प्रोसीडिंग है. ये सब सूट्स इन जनरल से रिलेटेड है. अभी हमने इंटरिम और इंटरलोकेटरी की कोई चर्चा नहीं की है सर, इस पे कोई सवाल जवाब अभी नहीं करेंगे प्रतीक जी। हम जब पढ़ाएंगे तो आपको बताएंगे क्या होता है इंटरिम और क्या होता है इंटरलोकेटरी। आगे आगे नहीं भागना है, मैं आपको बार बार मना करता हूं, ये सब ज्ञान का प्रदर्शन ना बहुत अच्छा नहीं है। अभी आपको फॉलो करना है सर, फॉलो करना है। यही पीछे की क्लास में आप लोगों ने कर करके ना क्लास को थोड़ा सा गड़बड़ कर दिया। सो प्लीज बिलीव मी सर, मैं आपके एक एक प्रश्न का अभी पढ़ाएंगे ना आगे। अब आप एड इंटरिम इंजंक्शन भी पूछ लो आज, तो मैं थोड़ी वो सब जवाब देने जा रहा हूं। अभी हम ना बिल्कुल सिस्टमेटिक मेथड से चलेंगे, हम आपके प्रश्नों को ऐसे नहीं लेंगे सर। आप देखो समझ नहीं पाते हो, कभी कभी बड़ा सिस्टम से चलना होगा आपको। यू हैव टू मूव वेरी सिस्टमेटिकली एंड इन डिसिप्लिन्ड मैनर। Information is oceanic, so you can ask anything. But this class is not meant for oceanic information. ये तो गूगल में टाइप करके भी प्राप्त कर लेगा आदमी, लेकिन गूगल में टाइप करके हाउ टू मेमोराइज अपील एंड हाउ टू सॉल्व दिस क्वेश्चन ये नहीं आएगा। वो हम लोग क्लास में करेंगे कि ये सिविल सूट की जर्नी कैसे चलेगी, ये गूगल में कितना भी टाइप करोगे तुमको ढंग से नहीं बताएगा। गूगल इज हेल्पलेस। और कोई भी लेक्चर सीपीसी का जो है यूट्यूब पे वो भी ठीक से नहीं बताता। मैंने सारे देखे कि कहीं कोई बहुत बेहतरीन चीज मिल जाए, मुझे नहीं मिला, आपको भी शायद नहीं मिलेगा। इसलिए हैव फेथ एंड पेशेंस एंड लेट मी डू माय जॉब एंड प्लीज बिलीव मी, गिव मी फ्रीडम, इट विल बी वंडरफुल एंड ब्यूटीफुल। हम कभी भी आपके ऐसे प्रश्नों का जवाब नहीं देना चाहेंगे जो कि आपके एग्जाम से रिलेटेड और टॉपिक से रिलेटेड नहीं हो। उससे क्या होता है ना, दिग्भ्रमित हो जाते हैं लोग। तो जितना मैंने आपको क्या कहा था, इनपुट मत बढ़ाओ, आउटपुट बढ़ाओ। आप नहीं समझ पाए हो शायद संदेश मेरा। इनपुट नहीं बढ़ाना है, आउटपुट बढ़ाना है। यू हैव टू रेज आउटपुट नॉट इनपुट। तो इनपुट के लिए तो इतनी जानकारी है, ले लो मुल्ला की 3 वॉल्यूम वाली किताब, पढ़ते रहो बैठ के। इनपुट नहीं बढ़ाना, आउटपुट बढ़ाना है सर, प्लीज मेरी बात सुनो। ऑलराइट, थैंक यू वेरी मच, गॉड ब्लेस यू। और जो जो आप सवाल पूछेंगे ना, हम टाइम आने पे सबका जवाब देंगे। इज दिस क्लियर? विल आंसर ऑल द क्वेश्चंस। थैंक यू, गॉड ब्लेस ऑल। सब ध्यान करेंगे, क्लास में रम जाना है और सारे पढ़ के आने हैं कल। चलो वो भाई, ऑल द बेस्ट, गुड नाइट, मिलते हैं अच्छे से।